As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Islam Moors.
My nationality is Moorish.
Tomorrow, the 11 men arrested in a highway standoff in Wakefield over the weekend will face a judge. State police say they were heavily armed, dressed in tactical gear, and headed for training in Maine.
In an armed standoff with police.
We've committed no crimes.
Jamal live-streamed part of the standoff. His group, Rise of the Moors, is one of 25 anti-government sovereign groups identified by the Southern Poverty Law Center last year.
They don't believe that they're citizens of the United States. They don't pay taxes. They don't seek driver's licenses or gun licenses.
President Margaret Huang says the group has claimed Rhode Island as its sovereign territory. On Saturday, the men were en route to training in Maine, strapped with tactical gear when they ran into police.
Any one part of the democratic anything promoting a two-party system is a domestic enemy.
Co-founder Jamal Latimer was among those arrested. His father tells WBZ people are misunderstanding his son's intentions.
Many months later.
Hear ye, hear ye, hear ye. All present have been to full honorable Judge Deacon, Judge of the Superior Court, now sitting moving for the transaction of criminal business. Draw near, your attendance, and shall be heard. God save the Commonwealth of Massachusetts. You may be seated. Closed down session.
Good morning, jurors. Has everybody been able to comply with the instructions that I reminded you of at the end of the trial yesterday? All jurors indicating the affirmative, either by saying so or nodding their heads. We're going to proceed to the last phase of the trial. Before I begin my additional instructions, I want to note for you, and it says this in the instructions, but you'll note even on the first page that in at least one place I made slightly changes to the instructions as printed. And as I stated in the formal instructions, if there are differences, please follow what I say aloud. Okay, so if there's any difference between what I say aloud,
sorry to interrupt. I think there's one procedural thing you just need to take care of first.
There is. Thank you.
Sorry, I don't mean to interrupt.
Councilman McConnell reminds me that we haven't finished the previous phase of the trial, in which I look to the defense to determine if the defense wishes to prevent arguments.
The defense does not, and Mr. Billavay rests.
In your honor, Mr. Lisa out for the recital.
You now heard arrested. They, as I explained to you at the beginning of the case, are under no obligation whatsoever to present any evidence at all, because each defendant is presumed innocent unless and until the Commonwealth proves their guilt on any given charge or charges beyond a reasonable doubt. They have no obligation to prove anything to you, and therefore are not required to present evidence. Thank you, counsel, for me. So just as a don't be thrown when you see that I deviate a bit on page 1 from the instructions. I don't think I hope it's not a significant point from anybody's perspective. But to the extent that I do deviate, please follow what I say aloud, which are my actual instructions. That said, jurors, thank you again for serving on this jury. Jury service is a very important part of our democratic self-government. You are responsible for upholding the law and our principles of justice. That is what you promised to do at the start of this trial when you took your oath as a juror. You must carefully consider all the evidence, decide whom and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that one or both of the defendants, Jamal Latimer, also known as Jamal Abdullah Bey, and Stephen Perez, also known as Lucha El por Libertad, committed some or all of the crimes with which they are charged. The final part of this trial involves 3 stages. First, I will give you instructions about the law that governs this case. Then, and this is the first place where I'm skipping some words, then the attorneys will make their closing arguments in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to reach. By custom, and because the Commonwealth bears the burden of proof, Mr. Thompson and Ms. Raisler-Cohn will argue first, for Mr. Latimer Abdullah Bey and Mr. Perez Lucia L. And Assistant District Attorney Van Epps will argue second for the Commonwealth. After the closing arguments, I will give you some guidance about how to conduct your deliberations. Then we will select the alternate jurors, and I will send you out to begin your deliberations. We will then work together to reach a verdict. Please pay close attention to my instructions. All of my instructions are important, and you must follow them, even if you do not agree with them. To make sure that I give you the instructions accurately, I will read them to you and see. You also have a written copy so you can read along if you wish, and have a copy of the instructions to refer to in the jury room during your deliberations. I will do my best to make sure that the instructions I give when speaking with you match the written instructions. However, as I mentioned a few moments ago, if there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. As I explained to you at the beginning of the trial, and just mentioned again just a moment ago, there is a fundamental rule that applies in all criminal cases, including this one. Every person who is accused of a crime in this country is presumed to be innocent of that crime. Mr. Latimer Abdullah Bey and Mr. Perez Lucia L. are presumed innocent of the charges in this case. That means you must consider them to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that they committed some or all of the crimes charged. I will once again explain what I mean by proof beyond a reasonable doubt in just a moment. Mr. Latimer Abdullah Bey and Mr. Perez Lucia L. do not have to do anything to convince you they are innocent. They do not have to explain anything. They do not have to testify, call, or question witnesses, or present any evidence at all, because you must presume they are innocent. Instead, it is up to the Commonwealth to prove the charges against Mr. Latimer Abdullah Bey and Mr. Perez Lucia L. beyond a reasonable doubt. This burden of proof never shifts to the defendant. Your verdict as to each charge against each defendant, whether it is guilty or not guilty, must be unanimous. All 12 of you must agree on the verdict. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about either defendant's guilt on a charge, then your verdict must be not guilty on that charge. You may find the defendants guilty on a charge only if all 12 deliberating jurors agree that the Commonwealth has proved his guilt beyond a reasonable doubt as to that charge. What is proof beyond a reasonable doubt? As I mentioned at the beginning of the trial, the term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until that person is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendants are entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that Mr. Latimer Abdullah Bey and or Mr. Perez Lucia L. are more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of each defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. As you know, there are several charges against each defendant. I will discuss the charges individually. As to most of the criminal offenses alleged in this case, the Commonwealth has charged each defendant both as a principal and or as a joint venturer. The exceptions are the charges against each defendant for wearing or using body armor in the commission of a felony, and the charge against Mr. Latimer Abdullah Bey for giving a false name to a police officer in connection with an arrest. Before instructing you on the elements of each of the specific crimes charged, therefore, I'm first going to instruct you on the principle of joint venture liability. Joint venture liability is not the same thing as guilt by association, which the law does not permit. To prove that each defendant is guilty as a joint venturer, the Commonwealth must prove that the defendant intentionally participated in the commission of a crime as something he wished to bring about and sought by his actions to make succeed. The Commonwealth is not required to prove that Mr. Latimer Abdullah Bey and or Mr. Perez Nietzsche L. each performed each of the acts or acts charged in each offense. If you find that there is evidence that more than one person may have participated in each of the offenses, the Commonwealth can prove Mr. Latimer Abdullah Bey's and or Mr. Perez Nietzsche L's guilt as to each offense if it proves two things beyond a reasonable doubt. One, Mr. Latimer Abdullah Bey and or Mr. Perez Nietzsche L knowingly participated in the commission of the crime alone or with others. And two, that each defendant did so with the intent the crime be committed. A defendant may knowingly participate in a crime in several ways. The defendant may personally commit the acts that constitute the crime. The defendant may aid or assist another or others in those acts. The defendant may ask or encourage another person to commit the crime or help to plan the commission of the crime. Alternatively, the defendant may knowingly participate by agreeing to stand by at or near the scene of the crime to act as a lookout, or by providing aid or assistance in committing the crime, or in escaping if such help becomes necessary. An agreement to help if needed does not need to be made through a formal or explicit written or oral advance plan or agreement. It is enough if the defendant and at least one other person consciously acted together before or during the crime with the intent of making the crime succeed. The Commonwealth must also prove beyond a reasonable doubt that at the time the defendant knowingly participated in the commission of the crime, he had the intent required for that crime. You are permitted, but not required, to infer the defendant's mental state or intent from his knowledge of the circumstances or any subsequent participation in the crime. The inferences you draw must be reasonable, and you may rely on your experience and common sense in determining the defendant's knowledge and intent. Mere knowledge that a crime is to be committed is not sufficient to make a defendant. The Commonwealth must also prove more than mere association with the perpetrator of the crime, either before or after its commission. It must also prove more than a failure to take appropriate steps to prevent the commission of the crime. Some active participation in or furtherance of the crimes charged is required to prove each defendant guilty as a joint venturer in that crime. Mere presence at the scene of the crime is not enough to find a defendant guilty. Presence alone does not establish a defendant's knowing participation in the crime, even if a person knew about the intended crime in advance and took no steps to prevent it. To find a defendant guilty, there must be proof that the defendant intentionally participated in some fashion in committing that particular crime, and that he had or shared the intent required to commit the crime. It is not enough to show that the defendant simply was present when the crime was committed or that he knew about it in advance. Finally, I emphasize that as you consider the charges in this case, you must consider each charge against each defendant separately. The first offense is possession of a large capacity weapon. It is count one of both indictments, the indictments against both defendants. The Commonwealth alleges in count one of each indictment that on July 3rd, 2021, Mr. Latimer Abdullah Bey and Mr. Perez Nietzsche L possessed a large capacity weapon or participated in a joint venture with others to possess a large capacity weapon. As I instructed you at the outset of the trial, to prove each defendant guilty of this offense, the Commonwealth must prove 5 things or elements beyond a reasonable doubt as to each defendant. First, the defendant possessed an item or had an item under his control in the vehicle. Second, the item met the legal definition of a large capacity weapon. Third, the defendant knew he possessed that firearm or rifle, that weapon, or had a firearm or rifle or weapon under his control in the vehicle. The defendant knew either that the firearm or rifle or weapon met the legal definition of a large capacity weapon, and or that the firearm or rifle or weapon was capable of holding more than 10 rounds of ammunition. And fifth, the defendant did not have a valid license to carry firearms at the time he possessed the weapon. The first thing the Commonwealth must prove as to each defendant is that the defendant possessed an item or had an item under his control in the vehicle. A person can possess an object by having direct physical control over it. For example, you possess whatever you hold in your pocket. A person can also possess an object if the person knows of the object, has the ability to exercise control over it, either directly or through another person, and has the intent to exercise control over it. For example, under the law, you possess items that you keep in your dresser or desk at home. Let me say one more thing about possession. Merely being present near an object or being associated with a person who controls an object or control the place where an object is found does not amount to possession. To find that someone possessed an object, there must be evidence to support the conclusion that the person knew of the object and had the ability and intent to exercise control over it. The possession does not have to be exclusive for one person. Someone can possess an item jointly with another person or other people. The second thing the Commonwealth must prove is that the item met the legal definition of a large capacity weapon. A large capacity weapon includes any firearm or rifle that is semi-automatic and is capable of accepting or readily modifiable to accept any detachable large capacity feeding device. That is, any detachable magazine, box, drum, bead strip, or similar device. You can see devices misspelled there, capable of accepting or that can be readily converted to accept more than 10 rounds of ammunition. The third thing the Commonwealth must prove is that each defendant knew that he had a firearm or rifle and also knew that the item was a firearm or rifle within the common meaning of those terms. This requires you to make a decision about the defendant's state of mind at the time he allegedly possessed the firearm or rifle. To do this, you may consider the defendant's actions, words, all the surrounding circumstances, and any reasonable inferences that you can draw from the evidence. To prove the fourth element of this charge, the Commonwealth must prove either that the defendant knew that the firearm or rifle met the legal definition of a large capacity weapon, or that the defendant knew that the weapon was capable of accepting or readily modifiable to accept more than 10 rounds of ammunition. Like the previous element, this element requires you to make a decision about each defendant's state of mind at the time he allegedly possessed the firearm or rifle, either himself or as a joint venturer. As I explained in connection with the third element, to do this, you may consider the defendant's actions and words, all of the surrounding circumstances, and the reasonable inferences that you draw from those circumstances. The fifth element that the Commonwealth must prove as to each defendant is that the defendant did not have a valid license to carry a firearm or rifle. And I think technically the name for that document, and you remember the evidence is what controls is license to carry a firearm. So I've added rifle, but technically it's license to carry a firearm. A license to carry a firearm is not the same as a firearm identification card or FID card. A license to carry a firearm allows a person to possess a large capacity weapon, firearm, rifle, or shotgun, either inside or outside the person's home or place of business. A firearm identification card allows a person to possess a firearm, rifle, or shotgun only inside the person's home or place of business. Additionally, if you find that one or both of the defendants was engaged in a joint venture to possess one or more of the weapons, the law requires that the Commonwealth prove that the joint venture was unlawful as to all the participants in the joint venture. In this case, that means the Commonwealth must prove that none of the joint venturers had a valid license to carry a firearm. If you conclude that the Commonwealth has not proved beyond a reasonable doubt that one or more of the weapons that each defendant is accused of possessing, either himself or as part of a joint venture, meets the statutory definition of a large capacity weapon, then you would consider the lesser included offense of unlawful possession of a firearm or unlawful possession of a rifle. Each defendant is charged with this offense with respect to other weapons, so I will instruct you on this offense in sections 5 and 6 of my instructions below. Now let's talk a little bit about the verdict form that you're going to have with you when you do your deliberations. If you conclude that the Commonwealth has proved all 5 of these things, that is the elements of the offense itself, beyond a reasonable doubt as to one or both defendants for one or more of the alleged large capacity weapons, then you would put a check mark on the line next to the word guilty for question 1 of the verdict form, pertaining to form or forms pertaining to the defendant or defendants as to whom you found the Commonwealth had proved all 5 things. You would then go on to place a check mark next to any of the large capacity weapons that the Commonwealth has proved beyond a reasonable doubt that one or both defendants possess, either themselves or as the defendants in the joint venture. So under the line marked guilty, there are check boxes for each of the 3 weapons alleged to be large capacity weapons, and you would put a check mark next to any of the weapons that as to which you concluded that the defendant whose verdict form you're filling out possessed. Then, as to whichever defendants you find that the Commonwealth has proved all the elements of the offense, you would go on to question 2 on the verdict slip for that defendant or those defendants. As to that defendant or those defendants, you would not consider the lesser included offenses discussed in the next paragraph. If, as to either defendant, you conclude, however, that the Commonwealth has not proved beyond a reasonable doubt that one or more of the 3 weapons meets the statutory definition of a large capacity weapon, but you find that as to one or more of those weapons, the Commonwealth has proved beyond a reasonable doubt the elements of one of the lesser included offenses, unlawful possession of a firearm or unlawful possession of a rifle, then you would check the box marked guilty for that lesser included offense. You would also place a check mark next to each of the weapons that the Commonwealth has proved beyond a reasonable doubt that one or both defendants possessed. If you conclude that the Commonwealth has not proved one or more of the elements of possession of a large capacity weapon and has not proved one or more of the elements of the lesser included offenses of unlawful possession of a firearm or unlawful possession of a rifle, then you would put a check mark on the line next to the words not guilty on question 1 of the verdict form pertaining to the defendants as to whom you found the Commonwealth had not proved one or more of these things. In either case, you would go on to answer question 2 of the verdict forms. Your verdict as to each defendant and each weapon must be unanimous. And that is true, by the way, of all the charges. The second charge is, as to each defendant, is possession of a large capacity feeding device. The things that the Commonwealth must prove beyond a reasonable doubt with respect to the second charge, possession of a large capacity feeding device, are very similar to the things that the Commonwealth must prove as to the charge of possession of a large capacity weapon, which is section 1 that I just instructed you on. So, to prove each defendant guilty of possession of a large capacity feeding device, either themselves individually or as part of a joint venture, the Commonwealth must prove 5 things. First, the defendant possessed a feeding device or had a feeding device under his control of the vehicle. Second, the item met the legal definition of a large capacity feeding device. Third, the defendant knew he possessed that feeding device or had that feeding device under his control of the vehicle. Fourth, the defendant knew either that the feeding device met the legal definition of a large capacity feeding device and or that the feeding device was capable of holding more than 10 rounds of ammunition. And fifth, the defendant did not have a valid license to carry firearms at the time he possessed the feeding device. As you can see, the things that the Commonwealth must prove to prove either defendant guilty of this offense are identical to the elements of the first charge, possession of a large capacity weapon, except of course that they pertain to the possession of a large capacity feeding device rather than possession of a large capacity weapon. The law defines a large capacity feeding device as a fixed or detachable magazine, box, drum, feed strip, or similar device capable of accepting or that can be readily converted to accept more than 10 rounds of ammunition. Please delete the word shells there. That's a straight editing error. It should say more than 10 rounds of ammunition. If you conclude that the Commonwealth has proved all 5 of these things beyond a reasonable doubt as to one or both defendants for one or more alleged large capacity magazines, then you would put a check mark on the line next to the word guilty on question 2 of the verdict form pertaining to the defendant or defendants as to whom you found the Commonwealth has proved all 5 things. You would then go on to place a check mark next to each group of alleged large capacity magazines that the Commonwealth has proved beyond a reasonable doubt one or both defendants possess, either themselves or as part of a joint venture. If you conclude that the Commonwealth has not proved one or more of these things beyond a reasonable doubt as to one or both defendants, then you would put a check mark on the line next to the words not guilty on question 2 of the verdict form pertaining to the defendants as to whom you found the Commonwealth had not proved one or more of these things. In either case, you would go on to answer question 3 in the verdict forms. Third charge, which is count 5 as to each defendant, is improper storage of a large capacity weapon near a minor. To prove each defendant guilty of improperly storing a large capacity weapon in a place where a minor would have access to it, or participating as a joint venturer with others in doing so, the Commonwealth must prove 5 things beyond a reasonable doubt. First, that the defendant knowingly kept or stored an item. Second, that the item in question satisfied the legal definition of large capacity weapon. Third, that the defendant knew either that the weapon met the legal definition of a large capacity weapon and or that he knew that the weapon was capable of holding more than 10 rounds of ammunition. Fourth, that the large capacity weapon was unsecured. That is, that it was neither secured in a locked container nor equipped with a tamper-resistant mechanical lock or other safety device properly engaged so as to render the weapon inoperable by anyone other than the owner or other lawfully authorized user. And fifth, that the large capacity weapon was stored or kept in a place where a person younger than 18 years old had access to it without committing an unforeseeable trespass. To prove the first element, the Commonwealth must prove that the defendant stored or kept an item. For purposes of this offense, a weapon is not deemed to be stored or kept if it is carried by or under the control of the owner or other lawfully authorized user. A person carries a weapon when that person has actual physical possession of it. If the person does not actually physically possess the weapon, it's not being carried. One has control of a weapon when one is sufficiently near it to immediately prevent its unauthorized use. If the person is not close enough to the weapon to immediately prevent its unauthorized use, the person is not in control of it. You may consider evidence, if any, about the location of the large capacity weapon or weapons, the location of the defendant or defendants, and any other relevant evidence to determine whether each defendant had control of the weapon or weapons in question. The second thing that the Commonwealth must prove is that the item in question satisfies the statutory definition of a large capacity weapon. This is the same as the second element of the offense of carrying a large capacity weapon. Please therefore refer to my instruction there on the statutory definition of a large capacity weapon. The third thing that the Commonwealth must prove, that each defendant knew that the weapon met the statutory definition of a large capacity weapon and or knew that it could hold more than 10 rounds, is the same as the third thing that the Commonwealth must prove as the charge of possession of a large capacity weapon. You should refer therefore to my instruction on that element in section 1. To prove the fourth element, the Commonwealth must prove that the large capacity weapon was unsecured. A weapon is unsecured when it is accessible to a person not authorized by law to possess it. A weapon is properly secured when it is either stored in a locked container or when it has an engaged tamper-resistant mechanical lock or other safety device. I instruct you that a locked motor vehicle is not itself a secure storage container. A safety device is properly engaged if it renders the large capacity weapon inoperable without any person other than the owner or other lawfully authorized user. The fifth thing the Commonwealth must prove is that the large capacity weapon was kept or stored in a place where a person under 18 years old could have access to it without committing an unforeseeable trespass. In this context, a trespass occurs when a person enters or remains in another person's dwelling without the permission of the person in lawful control of the premises. In order to constitute a trespass, the minor must have been forbidden, either directly or by a posted notice, to enter or remain in the dwelling. If you find that the Commonwealth has proved all the elements beyond a reasonable doubt as to one or both defendants, then you would put a check mark on the line next to the word guilty on question 3 of the verdict form pertaining to the defendants as to whom you found the Commonwealth to prove 5 elements, defendant or defendants, as to whom you found the Commonwealth to prove all 5 elements. You would then go on to place a check mark next to each of the large capacity weapons that the Commonwealth has proved, that is, any of the large capacity weapons, the Commonwealth has proved beyond a reasonable doubt that one or both defendants improperly stored, either themselves or as joint venturers. You would then go on to question 4 of the verdict. Like the charge of possession of a large capacity weapon, this charge is a lesser included offense, improper storage of a rifle or shotgun in a minor. I will instruct you on that charge next because both defendants are also charged separately with that offense in connection with other alleged weapons. So if you determine that the Commonwealth has proved the first, fourth, and fifth elements of this offense, that the defendant possessed an item, that it was unsecured, and that it was stored or kept in a place to which a minor had access to it, but that the Commonwealth has not proved either the third or fourth elements, that the item satisfied the legal definition of a large capacity weapon, and or that the defendant either knew that it met the statutory definition, or that it was capable, or knew that it was capable of holding more than 10 rounds of ammunition, then you should consider the lesser included offense of improper storage of a rifle or shotgun as to the weapons addressed in this indictment, in this count of the indictment. In that case, you would follow my instructions in the next section. If you conclude that the Commonwealth has not proved the first, fourth, and or fifth elements of this offense beyond a reasonable doubt as to one or both defendants, then you would put a check mark on the line next to the words not guilty on question 3 of the verdict form pertaining to the defendants as to whom you found the Commonwealth had not proved one or more of these things. In either case, you would go on to answer question. Right. In either case, you would go on to answer question 4 of each of the verdict forms. The next offense is improper storage of a rifle or shotgun near a minor, which is count 6 in the indictment against each defendant. You will remember that this is separately charged as some firearms. It is also the instruction on the lesser included offense of improper storage of a large capacity weapon. So it's serving double duty here. It's the instruction on one count against each defendant. It is also the instruction on the lesser included offense of the previous charge. And in both capacities, it's exactly the same. To prove each defendant guilty of improperly storing a firearm, rifle, or shotgun in a place where a minor had access to it, or of participating in a joint venture to do so, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant knowingly kept or stored an item. Second, that the item in question was a rifle or shotgun. Third, that the rifle or shotgun was unsecured. That is, that it was neither secured in a locked container nor equipped with a tamper-resistant mechanical lock or other safety device, properly engaged so as to render the weapon inoperable by anyone other than the owner or other lawfully authorized user. And fourth, that the rifle or shotgun was stored or kept in a place where a person younger than 18 years old had access to it without committing unforeseeable trespass. The first, third, and fourth elements of this offense are the same as their counterparts in the offense of improper storage of a large capacity weapon in a place where a minor has access to it, section 3, which I just instructed you on, except that the elements apply to rifles and shotguns as opposed to large capacity weapons. So please review my instructions on that offense as to the first, third, and fourth elements of this offense. The second thing that the Commonwealth must prove as to this offense is similar to, but distinct from, the second element of the offense of improper storage of a large capacity weapon access to it. The second element of this offense is that the item in question is a rifle or shotgun. A rifle is defined in our law as a weapon having a rifle bore with a barrel length equal to or greater than 16 inches and capable of discharging a shotgun bullet for each bullet trigger. A shotgun is defined as a weapon having a smooth bore with a barrel length equal to or greater than 18 inches, with an overall length equal to or greater than 26 inches, and capable of discharging a shotgun bullet for each pull of the trigger. If you find that the Commonwealth has proved all the elements beyond reasonable doubt as to one or both defendants, then you would put a check mark on the line next to the word guilty on question 4 of the verdict form pertaining to the defendants as to whom you found the Commonwealth has proved all 4 elements. You would then go on to place a check mark next to the rifle and or shotgun that the Commonwealth has proved beyond reasonable doubt that one or both defendants properly stored, either themselves or as part of a joint venture. If you conclude that the Commonwealth has not proved one or more of these things beyond reasonable doubt as to one or both defendants, then you would put a check mark on the line next to the words not guilty on question 4 of the verdict form pertaining to the defendants as to whom you found the Commonwealth had not proved one or more of these things. In either case, you would go on to answer question 5 in each of the verdict forms. The fifth offense, unlawful possession of a firearm without a license, is charged as count 3 against each of the defendants. To prove that either defendant possessed a firearm without a license or participated in a joint venture with others who possess a firearm without a license, the Commonwealth must prove 4 things beyond reasonable doubt. First, the defendant possessed a firearm. Second, what the defendant possessed met the legal definition of firearm. Third, the defendant knew that he possessed a firearm. Fourth, the defendant did not have a valid license to carry a firearm. The first thing that the Commonwealth must prove is that each defendant possessed an item of firearm. I defined possession for you in my earlier instruction, section 1 on possession of a large capacity weapon. You should apply that definition to this charge as well. The second thing that the Commonwealth must prove is that what Mr. Latimer Abdullah Bey or Mr. Perez Muchael had in their possession met the legal definition of a firearm. As relevant to this case, a firearm is defined as a pistol or other weapon of any description from which a shot or bullet can be discharged and of which the length of the barrel or barrels is less than 16 inches. Thus, to be a firearm under the law, an item must meet 3 requirements. First, it must be a weapon. Second, it must be capable of discharging a shot or bullet. And third, it must have a barrel length of less than 16 inches. A firearm's barrel is that portion of the firearm through which a shot or bullet is driven, guided, or stabilized, and includes the chamber. The third thing that the Commonwealth must prove is that each defendant knew that he possessed a firearm. I instructed you on the issue of knowledge earlier in my instruction, section 1, possession of a large capacity weapon. You should apply that instruction to this charge as well. The Commonwealth must prove that each defendant knew that what he possessed was a firearm. If you find, however, that the item was a conventional firearm, it's obvious dangers. The Commonwealth does not have to prove that the defendants knew that the item met the legal definition of a firearm. The last thing that the Commonwealth must prove is that the defendants did not have a valid license to carry a firearm. Our law requires that a person who possesses a firearm outside of his home or place of work must have a license to carry a firearm. I explained what a license to carry a firearm is in my earlier instruction, section 1, on possession of a large capacity firearm. Bear in mind, as I instructed you with respect to possession of a large capacity weapon, if you find that one or both of the defendants was engaged in a joint venture to possess one or more of the weapons, the law requires that the Commonwealth prove that the joint venture was unlawful as to all the participants in the venture. In this case, that means the Commonwealth must prove that none of the joint venturers had a license to carry a firearm. Here again, if you conclude that the Commonwealth has proved all 4 of these things beyond reasonable doubt as to one or both defendants, then you would mark a check on the line for guilty, the appropriate question on the verdict form for each defendant. You would then go on to place a check mark next to each of the firearms that the Commonwealth has proved beyond a reasonable doubt that one or both defendants unlawfully possessed, either themselves or as joint venturers. If, however, you conclude that the Commonwealth has not proved one or more of these things beyond reasonable doubt as to one of those defendants, then you would put a check on the line next to the word not, words not guilty. Either way, you go on to question 6 on each verdict. The sixth instruction I'll give you is on unlawful possession of a rifle or a shotgun without a license, which is 4 on the indictments as to each defendant. To prove that either defendant possessed a rifle or a shotgun without a license, or participated in a joint venture to do so, the Commonwealth must prove 4 things beyond reasonable doubt. First, the defendant possessed the rifle or shotgun. Second, was the defendant possessed met the legal definition of a rifle or shotgun. Third, the defendant knew that he possessed a rifle or shotgun. And fourth, the defendant did not have a valid license to carry a rifle or shotgun. All 4 things that the Commonwealth must prove are similar to the 4 elements of the offense of unlawfully carrying a firearm, which is Section 5 of the instruction that is stated. So, as to the first thing the Commonwealth must prove, the definition of possession is the same as it is in the first elements of both possession of a large capacity weapon, Section 1, and unlawfully carrying a firearm, Section 6. That says Section 6, which should say Section 5 above. You should therefore refer to the definition of possession that I provided in Section 1 above, the offense of possession of a large capacity weapon. As to the second thing the Commonwealth must prove, the definition of the term rifle and shotgun are the same as the definitions that I gave you in connection with the second element of the offense of improper storage of a rifle or shotgun near a minor in Section 4. The third thing the Commonwealth must prove is that each defendant knew that he possessed a rifle or shotgun. As I mentioned in my instruction on the third element of the offense of unlawfully possessing a firearm without a license, I instructed you on the issue of knowledge earlier in my instruction Section 1 of possession of a large capacity weapon. You should apply that instruction to this charge as well. The fourth thing that the Commonwealth must prove is that each defendant did not have a valid license to carry a rifle or shotgun. Once again, as I instructed you with respect to possession of a large capacity weapon and unlawful possession of a firearm, if you find that one or both of the defendants was engaged in a joint venture to possess one or more weapons, the law requires that the Commonwealth prove that the joint venture was unlawful as to all the participants in the joint venture. In this case, that means the Commonwealth must prove that none of the joint venturers had a valid license to carry a firearm. If you conclude that the Commonwealth has proved all 4 of these things beyond reasonable doubt as to one or both defendants, then you would mark a check on the line for guilty for the appropriate question on the verdict form for each defendant. You would then go on to place a check mark next to each of the weapons that the Commonwealth has proved beyond reasonable doubt that one or both defendants unlawfully possessed, either themselves or as joint venturers. If, however, you conclude that the Commonwealth has not proved one or more of these things beyond reasonable doubt as to one or both defendants, then you would put a check on the line next to the words not guilty. Either way, you would go on to question 7 of each verdict. The 7th offense alleged, carrying a loaded firearm without a license, is count 10 in the indictment against Mr. Latimer and L, and count 9 in the indictment against Mr. Perez and L. To prove that either defendant unlawfully carried a loaded firearm or participated in a joint venture to carry a loaded firearm, the Commonwealth must prove 6 things beyond reasonable doubt. The first 4 things that the Commonwealth must prove to make out this offense are the same 4 things that it must prove to convict the defendants of unlawful possession of a firearm. That is, as to each defendant, the Commonwealth must prove that first, the defendant possessed a firearm, second, that what the defendant possessed was the legal definition of a firearm, third, the defendant knew that he possessed a firearm, fourth, the defendant did not have a valid license to carry a firearm. Beyond these 4 things, the Commonwealth must also prove fifth, the firearm was loaded, and sixth, the defendant knew it was loaded. With respect to the 5th element, the law defines the word loaded to mean that ammunition is contained in the weapon or within a feeding device attached to the weapon. As to the 6th thing the Commonwealth must prove, that the defendant knew that the firearm was loaded, please review the instruction that I gave you regarding carrying a firearm without a license, Section 5, about how to decide whether the Commonwealth has proved that the defendant knew that the item he carried was a firearm. Thus, we may examine the defendant's actions and words and all the surrounding circumstances to help you determine whether he knew that the firearm he allegedly carried was loaded. Once again, if you conclude that the Commonwealth has proved all 6 of these things beyond a reasonable doubt as to one or both defendants, then you would mark a check on the line for guilty, the appropriate question on the verdict form for each defendant. You would then go on to place a check mark next to each of the weapons that the Commonwealth has proved beyond a reasonable doubt that one or both defendants unlawfully carried, either themselves or as joint venturers. If, however, you conclude that the Commonwealth has not proved one or more of these things beyond a reasonable doubt as to one or both defendants, then you would put a check on the line next to the words not guilty. Either way, you would go on to the next question of each verdict. The 8th offense alleged, unlawful possession of ammunition, which was count 11 as to Mr. Latimer and Bill Bay, count 10 as to Mr. Perez and Mr. L. To prove that either defendant unlawfully possessed ammunition or possessed or participated in a joint venture to unlawfully possess ammunition, the Commonwealth must prove 4 things. They are: first, the defendant possessed an item; second, the item meets the legal definition of ammunition; third, the defendant knew that he possessed that ammunition; and fourth, the defendant did not have a valid firearms identification (FID). The first thing the Commonwealth must prove is that the defendant possessed an item. In deciding whether the Commonwealth proved this element, please review my instruction on the first element of the offense of possession of a large capacity possessing a large capacity firearm, section 1, in which I explain what it means under the law of possessing. The second thing that the Commonwealth must prove is that the items the defendants possess meet the legal definition of ammunition. Ammunition is defined as cartridges or cartridge cases, primers or igniters, tear gas cartridges, bullets, or propellant powder designed for use in a large capacity weapon, firearm, rifle, or shotgun. With respect to this element, we shall conclude unanimously that each defendant possessed or participated in a joint venture to possess at least 1 round of ammunition meets the legal definition. The third thing that the Commonwealth must prove is that the defendant knew that he possessed ammunition. In deciding whether the Commonwealth has proved this element, knowledge, please refer to my instruction on the third element of count 1, possession of a large capacity weapon. The final thing that the Commonwealth must prove is that the defendant did not possess a valid firearms identification card. In this context, please refer to the instruction that I gave you as the 5th element of the offense of possession of a large capacity firearm, count 1. Bear in mind, as I instructed you with respect to possession of a large capacity weapon and other alleged offenses, if you find that one or both of the defendants was engaged in a joint venture to possess 1 or more rounds of ammunition, the law requires that the Commonwealth prove that the joint venture was unlawful to all participants in the joint venture. In this case, that means the Commonwealth must prove that none of the joint venturers had a valid FID card. If you conclude that the Commonwealth has proved all 4 of these things beyond a reasonable doubt as to one or both defendants, then you would mark a check on the line for guilty for the appropriate question for verdict form for each defendant. If, however, you conclude that the Commonwealth has not proved 1 or more of these things beyond a reasonable doubt as to one or both defendants, then you would put a check on the line next to the words not guilty. Either way, you would go on to question 9 of each verdict. 9th charge, use of body armor in the commission of felony, is count 7 as to both Mr. Latimer and Abdullah and Mr. Perez and Lucia. To prove that Mr. Latimer, Abdullah and or Mr. Perez Lucia used body armor in the commission of felony, Commonwealth must prove 3 things beyond a reasonable doubt. First, the defendant wore or otherwise used equipment. Second, the equipment was made of resin-treated glass fiber cloth or other materials designed to effectively deter or prevent the bodily damage incurred by knives, ammunition, or other weaponry. And third, the defendant used the equipment during a commission or attempted commission of another separate felony. As to the first thing the Commonwealth must prove, you are to give the words wore and use their ordinary meanings. So a person wears something when the person clothes themselves in the item. A person uses an item when the person employs it for a particular purpose. The second thing that the Commonwealth must prove is that the equipment was made of resin-treated glass fiber cloth or other materials designed to protect the wearer or user from bodily injury from knives, ammunition, or other weapons. The third thing that the Commonwealth must prove is that each defendant wore or used the equipment during a commission or attempted commission of another felony. In this context, I instruct you that the other offenses for which each defendant is charged, except for the offenses of unlawful possession of ammunition, which both defendants were charged with, and providing a false name to a police officer in connection with an arrest with which Mr. Latimer Obey is charged, are felonies. So that is, all the offenses that we're charged with, except those two, are felonies. So if you find that the Commonwealth has proved both of the first two elements of this offense, and at least one of the other felony offenses with which each of the defendants is charged, with the exception of the charge of possession of ammunition and the charge against Mr. Latimer Obey for providing a false name to the police officer, then you would find the defendant guilty of this offense. If, however, you conclude that the Commonwealth has failed to prove one or more of the elements of this offense, then you would find him not guilty of this offense. In either event, you have completed the verdict form with respect to Mr. Perez Lucia L, but you would go on to question 10 from the verdict form for Mr. Latimer Obey. The 10th instruction, which applies only to Mr. Latimer Obey, is the offense of furnishing a false name to a police officer in connection with an arrest. To prove that Mr. Latimer Obey knowingly gave a false name to a police officer in connection with an arrest, the Commonwealth must prove three things. First, Mr. Latimer Obey gave the police a false name. Second, that it was he did so in connection with his arrest. And third, that he did so intentionally. The first thing that the Commonwealth must prove is that Mr. Latimer Obey gave the police a false name. A false name is one that is provided for a dishonest purpose. Under the law, individuals can change their names as they please by merely adopting another name. A person does not have to go through legal proceedings to use a different name, provided that the person is not doing so for a dishonest purpose. Examples of dishonest purposes for changing one's name include to conceal one's criminal record to avoid being charged as a repeat offender, concealing one's criminal record to obtain more favorable bail consideration, concealing one's identity to avoid answering to an outstanding warrant, or creating a new identity with the intent to default and avoid prosecution from the charge for which one has been arrested. If a person previously has identified himself to any police department under a name that is different than the name he used following the arrest in this case, and failed to disclose his prior use of a different name, you are permitted to infer that his failure to make such a disclosure was for a dishonest purpose and that he was using a false name. You do not have to draw this inference, but you may do so. It is entirely up to you. The Commonwealth does not have to prove the defendant's true name. It must prove that he used a false name, that is, that he used a name for a dishonest purpose. The second thing that the Commonwealth must prove is that Mr. Latimer Obey gave police a false name in connection with an arrest. The third thing the Commonwealth must prove is that Mr. Latimer Obey gave a false name knowingly and willfully, as opposed to negligently, inadvertently, unintentionally. As I explained to you at the outset of this trial, I am required to have no opinion about the facts of this case. You therefore do not take anything I have said or done during this trial as any reflection of my opinion. Specifically, with regard to this charge, you have noticed that I have referred to Mr. Latimer Obey and Mr. Perez Lucia L by the names that they prefer, Mr. Obey and Mr. Lucia L. I have done so out of respect for their choices of names, but my doing so has no bearing on whether the Commonwealth has proved this charge. The issue is Mr. Latimer Obey's alleged conduct on July 3rd, 2021. My decision as to how to address the defendant in court has absolutely no bearing on that alleged conduct, and you must therefore not consider it in any way to evaluate this charge. Once again, if you conclude that the Commonwealth has proved all three of these things beyond a reasonable doubt, then you would mark a check on the line for guilty for question 10 of Mr. Latimer Obey's verdict. If, however, you conclude that the Commonwealth has not proved one or more of these things beyond a reasonable doubt, then you would put a check on the line next to the words not guilty. And assuming that you've recorded verdicts all along in sequential order, you would then be finished with the verdict form from Mr. Latimer Obey. Bear with me for a moment. I need to speak to the attorneys over a headset, and I'll be right back. Members of the jury, it's now time for counsel to present their closing arguments to you. Closing argument, as I mentioned at the outset of the trial, is each attorney's opportunity to argue to you as to what the evidence is to draw from it. By custom, because the Commonwealth has the burden of proof, counsel for the defendants argue first. Who will be Mr. Thompson?
Thank you, Your Honor. So, right now, you all know that Mr. Goulet is serving the United States Marine Corps. He's a former Marine. And case occurred on July weekend. Mr. Goulet and a group of others loaded up in cars and drove to me. Whether it is rainy, the atmosphere is damp, it's the rain. We stopped on the side of the road at a little after 1 o'clock in the morning. State highway. Sometime later, we see that the highway gets shut down. On some of the body worn cameras, you can hear the wind blowing because now there's not the background noise of all the cars driving by. It's like you're standing at the edge of the beach and you hear that wind blowing over your ears. And as you see the different camera angles of the body worn camera, when the police lights hit the lens the right way, you can see the water droplets on the camera lenses. And you know it's cold out, even though it's the beginning of July, because you hear some of the people talk about how they're freezing. I'm going to play for you the exhibit number from Mr. Goulet's body worn camera. This is the one ending in 85139. So this is Mr. Goulet's, before I play it, this is Mr. Goulet's body worn camera. It's 4:21 in the morning. Now we know the timestamps are off on the body worn camera at the bottom of the screen. But we know it's 4:21 in the morning because as you hear the wind blowing, you see Mr. Goulet holding that phone out in front of him. And we see that it's 4:21 on the cell phone. And on the backdrop, the wallpaper, there's a picture of an infant child. You hear him send a text message. He expels breath. He walks over to what appears to be Queen Cumberlander. Now you know from the R&B records that Mr. Cumberlander is one of the older people in the group. Mr. Cumberlander, as you see him, he's standing. He's facing the police line, where we know from one of the stop troopers that there are dozens of SWAT and stop troopers there. We know from Trooper Casey that it was the largest police presence he'd ever seen. Mr. Cumberlander standing there facing the Bearcats, and he's got his hands behind his back as though he's at some sort of parade rest, like you see a soldier doing in the military. And his hands are not on whatever weapon he's holding. And if you remember from yesterday afternoon, you hear Mr. Goulet and Mr. Cumberlander talking to each other. Mr. Goulet says, "We ain't dying today." And he says, "We're just gonna fucking surrender if it comes to that." Then he says, I'm ready to die. They don't gotta do that. Then Mr. Abdullah, being the former Marine, goes over to two other members of the group and essentially checks on them. These are the two people holding the flag of Morocco. The one on the left says he's cold. You hear that wind blowing. And that one on the left too, that Mr. Abdullah speaks to at first, you'll notice he has an American flag on his chest. Hear Mr. Abdullah say, "You good?" So the person responds, "It's cold." Mr. Abdullah says, "I know. How you feel?" Then he goes over to the other person holding the flag of Morocco. Looks like Arnold Pierre. Mr. Abdullah checks on him. Then he goes off to a third person, checks on him. I'm going to play that for you.
Any update on the news on this part?
The promo been drummed into you now that the burden of proof in this case is beyond a reasonable doubt. That burden protects every single person on American soil. Whether you're a citizen, not a citizen, passing through. It is the highest burden of proof anywhere in the American court system. It's not maybe, it's not, it probably, it is the highest burden. And the prosecution must prove each and every one of these elements beyond a reasonable doubt. And if they have not proven that beyond a reasonable doubt, Mr. Abdullah is entitled to the benefit of that doubt. I mentioned in my opening statements that the indictments can broadly be broken down into a few categories. They've got unlawfully possessing weapons and ammunition that Mr. Abdullah is accused of having directly on him. There's another grouping of unlawfully possessing weapons and ammunition that other people had under the so-called joint venture theory that the judge just directed on you. There's the improper storage of firearms charges. There's the body armor, and then the false statements. So on this joint venture idea, I want to go to the testimony you heard of the fingerprints, a little bit about the DNA that you heard about, and then really sort of the ballistics witness in some of his testimony. So there is some evidence of a joint venture. If there wasn't any evidence, that charge wouldn't be supported. So there is some evidence of a joint venture. But the push and pull of it is that the burden of proof is still beyond a reasonable doubt. It is not a maybe, it is not a probably, it is a beyond a reasonable doubt. So as you consider the strength of the government's case, I ask you to consider the fingerprints and the DNA issue. So they had Trooper Heather Sullivan come in and testify about the lack of fingerprints that were on the ballistics evidence. And we know through the limited testimony of other Trooper Sullivan yesterday afternoon that DNA testing was done, sent to a lab, and then results come back. Now, we didn't hear from somebody from the crime lab or anywhere else testifying about what those reports were. But I would suggest to you all that if those results were bad for Mr. Abdullah, that you would have heard about those results. So then the question becomes, with people watching crime shows on TV, isn't it just good police work to always test for DNA, test for fingerprints, you test for all this scientific fancy microscopic evidence? And it probably is good police work. Except here, Sergeant Jones, who is the ballistics witness, he testified that that's not actually something that they do automatically in every single case. He testified to all the experience he has in doing this, and they, being law enforcement, do not, or the crime lab, they do not always test for the DNA or fingerprints. So if you think about this, before that testing is done, what's the evidence they have on July 3rd? They have numerous police eyewitnesses to what happened. Body-worn camera from the police and a drone up in the sky. And at least one of the stop troopers was watching him on some kind of social media. Then within a few weeks, they pulled the body-worn camera files off of Mr. Abdullah Bey's body-worn camera. But even by the time they have that, knowing that they have an incredibly high burden, the prosecution requests that DNA and fingerprint testing be done on the ballistics. Even though they had all the evidence that I just described from July 3rd and then the body-worn camera from the Abdullah Bey. Knowing this high burden, they still didn't think it was enough as far as the joint venture theory. So back to the people watching crime show as well. Just because there's no DNA, that doesn't mean that the defendant is not guilty, and just because there's no fingerprints, that doesn't also mean that the defendant is not guilty. So what to do about that? And I would concede as much at that point, because it's true. And it's also not the case that while it would be good police work to always test, they don't. And I just discussed that point. But it goes to show the mindset of the DA's office when they think about assembling their case against Mr. Abdullah Bey. We have in terms of her chronology, I don't have a memory of when Trooper Heather Sullivan said that she did her fingerprint testing. We know from one of the other witnesses that the body-worn camera was pulled off within days or weeks of it being seized from Mr. Billigay's phone, excuse me, from his body-worn camera. We know from Trooper Delaney earlier this week that he did the extraction at least by September 1st. But then what sort of wraps that all up is Sergeant Jones tells us that that the DNA and the fingerprinting had been done before he conducted his testing in December. So the government really has a tall order approved here with the joint venture theories in saying that Mr. Abdullah is somehow responsible for stuff that other people have on it. Now, count 3 for Mr. Abdullah. So this is, I know there's a ton of these. Count 3 is for what you might call pistols or handguns. What the law calls a firearm is being distinct from the rifles or shotguns. So there's essentially very little, if any, evidence that Mr. Abdullah had any actual possession or directed anybody control over pistols or handguns, firearms. Now you heard from Trooper Casey that Mr. Abdullah had I can't really see it in the videos, but you heard from Trooper Casey that Mr. Abdullah had a pistol holster on him, but that it was empty. So then, I'm just gonna grab this vest. He had a pistol holster on him, but that it was empty. He saw the rifle magazines in the vest, but he makes no mention of there being any pistol magazines. We know from Trooper Donovan, the stop trooper who took Mr. Abdullah into custody and collapsed at the end of this whole thing, that he didn't have a memory as to whether there was any ammunition on the vest. Then there's the Telegram chat, which I'm sure you'll hear a lot more about later this morning, but you don't see anything about this with the Telegram chat either. You hear in one of the videos, supposing Mr. Abdullah saying to somebody, "You're a sniper, go get your sniper," but there's nothing that there's no inference that anything related to being a sniper has anything to do with this. And if Mr. Abdullah is going to be walking around with the rifle magazines, the rifle, but no pistol, and there's no indication of pistol ammunition, I mean, where's the pistol evidence? On the false name, one really doesn't know what to tell you on this. The evidence is that by July 3rd, 2021, he was known by the name Jamal Abdullah. You see it in the Telegram chats that, at least as far back as June 6th, 2021, he was referring to himself as Jamal Abdullah. There's a fair inference that those two points are exactly where it is. Now, the Commonwealth has this claim. We didn't really play with it during evidence, but you can have this docket sheet in evidence with you. It's essentially showing they had a warrant for unlicensed operation of a motor vehicle, which is a criminal offense, and then a civil infraction for speeding. On the next page, you see there was a warrant for that. On the third page, you'll see that this case was so incredibly serious that it was dismissed and then he was found not responsible in the civil infraction. Commonwealth, I believe, could be wrong, but I believe they have this theory that he made up the name Jamal Abdullah to duck a warrant on that was over a year old at that point. And then he keeps up the act with pretend name, talking to members of what you might call the Moorish community, and it's all to cover up that his real name is Jamal Lederer, try to avoid a warrant on this. You heard something about, some evidence that some of these people were presenting these Moorish identification cards. Mr. Bilbay is not one of them. The name he gave to Casey before he was technically under arrest, he gave the name Jamal Abdul-Labay. Then he confirms that information with the other pardon me, I forget his name, but the trooper came, the state police trooper came in yesterday to talk about you heard Mr. Bilbay confirming the details on the body worn audio. So just the evidence is, at least on the Telegram chat, he was holding himself up at people who were probably not police officers as Jamal Abdul-Labay. Well, the Telegram chat, you'll have it in the evidence room with you. See them talking about getting ready for their outings, something they're called an Operation Fountainhead. I just, the thing I highlight from that is, it does say get ready to sweat, not ready to die, bleed, kill, anything extreme like that. Now, you used the term earlier, a self-styled militia. Use that terminology deliberately, self-styled. There's no claims by the defense today that this was a real militia within the meaning of the law. Broadly speaking, with the statements that you have, and of course there are many, the one way to group them is the statements among the group before the highway encounter, which I would suggest is an insulated group. Then you have the statements that are made in the presence of the police, where somebody would put on a good showing or a good face. And then you have what they're saying more in private while they're outside the presence of the police. And then you've got the statements that are essentially being on Instagram where the circulation is go to read full live and I think they still do questions for you. On the improper storage, I would direct you to that first portion of the judge's instruction. The only time that these weapons are truly unattended is after they put them in the van for the vehicles for the surrender. It showed you the other day, the lady, a video of them in one of the cars. There's no indication that they're just playing around. And I would suggest that the way the weapons are found in the two cars, when the police go through them with that more thorough search and safety standards later that well into the following night, I would suggest to you that those were all placed there as part of the surrender. To the extent you might think that some of them were just left in there, maybe some guys who are walking around unarmed, or maybe they left a rifle or their shotguns in the car alone. I just again direct you to the instruction about the true owner or the person has it still being able to exercise immediate control. Now I'm going to put up another video for you in a moment. This was one of the ones we heard yesterday afternoon, and this is the one where I'll do it now. You can. I'll play the video first. So this is where Mr. Abdul-Labay is going back and talking to the group, saying we're not going to put our fucking arms down. And I could be wrong, but I'm pretty sure that the Commonwealth is saying that Mr. Abdul-Labay, that out of the rifles that you have in evidence, that his is the one that's the Ruger. So there's a Panther arms, there's a palmetto state armory rifle. There's a few different ones. I'm pretty sure that they're saying that his is the Ruger AR 5.56, I believe it is. one of the reasons for that, besides, whatever distinguishing features that rifle has on it, we heard from Sergeant Jones that this one had a round in the chamber. And while Mr. Gilday is saying we're not going to put our fucking arms down, you hear a clicking sound, and arguably it sounds like somebody's chambering a round to get it ready to shoot. It's a natural human reaction to have that sound be a little bit chilling, especially hearing it for the first time. But and I think I hit on this in a voting statement with you as well. The charges before you say are possession related, false name, improper storage, and the body armor. Notwithstanding the 2 cell phone distractions, all the photos, the Telegram chat, body worn camera from Mr. Gilday, and the police, and the drone video. If there's a plan to go out and kill a bunch of people or go tell the police, you would hurt. Go ahead and start playing. So this is and I'm mindful of my time, Your Honor. Okay. This is the exhibit ending in, so this is from Mr. Gilday's body worn camera, exhibit 134, the file ending in 6136. Yeah, I get the right click it. Yep. All right, so I'm going to skip to where the timestamp on the bottom is at about 16:18, about 50 or so. Just started at 16:18:41. We're now going to on launch. Pause that. Taking out exhibit 79 for you. So this is the rifle that says Ruger here, where the magazine will go in on the left side. We saw Sergeant Jones do a demonstration of this the other day with Attorney Van Mindful that there's the zip tying there, just keep that in there. That's as good as you're going to get with the zip tying there. But fair to say, even without the demonstration from Sergeant Jones, it does sound like at least the charging mechanism means. Throughout the case, and this was raised by myself and by opposing counsel in both of our openings. One side is trying to paint Mr. Gilday as a criminal mastermind who prepares and equips people and tells people to buy all this equipment for an operation. Fountainhead, he's got the obedience of the people he calls his men, and therefore he's guilty of everything that quote unquote his men have done. You hear him tracking around or chambering around. Then he goes ahead and later in the video just walks up to the police and keeps talking to them like he didn't just chamber around. They alluded to also, you know, if it really was their intention to do militia training, as though there was something else they were going to do, notwithstanding all the evidence that you heard being put into evidence. Other side is trying to remind you that Mr. Bill is a human being. They all thought they were going on a glorified camping trip for the 4th of July weekend. And notwithstanding this situation that occurred, Mr. Abdul Bay was able to keep his head full, his head level. You see that the highway does eventually get shut down. And we hear that somebody say that if you see that the police have now changed their positions, they fall back, I don't know if that's a technical term, but they fall back to their cruisers. They're behind the bright lights. And you hear on the body worn camera that they're loading their arms. They're getting their arms up. At some point, you see that one of those, I forget if it was a trooper or one of the Wakefield officers, but he's standing in between Trooper Casey's cruiser and the guardrail. He didn't really do much talk, but he's gone as well. And then there's this silence because now it's clear that the highway's been shut down. So I'm going to skip ahead to uh, 16/19/39 on the timestamp. And I'm going to start playing at 16/19/34. And so this is after Mr. Abdullah Bay's chamber that round. You'll see one police officer or trooper in between Trooper Casey's cruiser and the guardrail, and then he starts talking to the people. Still get the cars driving by.
So make sure if they start walking towards us, spread out.
And so on that timestamp, we know the timestamps are slightly out, but I just do that for the purposes of the record. And then there's more talk with Mr. Abdullah Bay and the police after this. Now I'm going to go to, on that same exhibit, the filing in 64137.
Yeah, absolutely. So I didn't understand. So I was trying to address him to see.
I'm going to skip ahead to where the timestamp at the bottom says 16:44:10. And this is during and slightly after his conversations with Sergeant McDevitt.
You're ready because they're talking about the possibility of an arrest. You might have to get ready because they're talking about a possibility of an arrest.
Now I'm going to skip to the timestamp 16:57:00. She wrote down the wrong spot, but I see what it is in the video. All right, so I was jumping at 16:45:01. And this is where you see that the police are gone. The highway's shut down. We're back to hearing the wind now. And where are the police that were just standing there?
Yeah, it's still on the road. Are you ready? Of course, I can't get arrested. Okay. I'll choose the arrested.
Obviously, I apologize.
So them nine
So there's the two clips of the same day. I'm doing a 16:57:00.
Go live. Yeah. On Instagram. Another one? I think another car did blow up on.
So you heard somebody say they're loading up, and then I'm gonna skip ahead 1 minute. And that's 16:59:08.
They do? All right,
So they've got their arms out. There's no threats or anything like that from Mr. Bilbay. They were still talking to Sergeant McDevitt, and the police ship disappeared. Whose fault the standoff isn't the issue. The issue is how did Mr. Bilbay respond? Later in that clip, like you just said, I probably over time, says I gave him my information. The following this video is that the spike of adrenaline, not quite a panic, but the alert. This is where it became a life death situation for people who look like Mr. Bilbay, the people who are with him, against a line of police officers. Later, you see them eating food out in broad daylight. They stay out in the open. You take a standoff. This isn't a bunch of people all pointing guns at each other, waiting for the other person to see if they're going to flinch. This is the videos are all of them out in the open. Saw the men earlier holding the Moroccan flag. No resisting or violent arrest charges. There's something like 9 hours of video the trooper said yesterday afternoon. Most the parts reporting for evidence that are relevant. We heard from the one of the body worn cameras yesterday. You hear Mr. Bilbay talking to a police officer on the phone. This is for your men, for your family. Call the media, tell them we're not anti-government. Just listen to his tone on that. Then I want to end with this. So what was supposed to have been the 4th of July weekend ends up with Mr. Abdullah coming out disarmed, sitting on a blue bucket, putting exhibit 21 on the overhead. I would suggest to you that Mr. Abdullah is the one third from the right. He's got some sort of headwear, not one of the guys with the helmet, but the headwear that you saw earlier in Duplicate's video. His right leg is up. Having been on the blue bucket earlier, we heard that the men decided on their own to lock arms like that. You see Mr. Abdullah's head is low, his shoulders are sagging, and the men to either side of him are essentially holding him up. 24 is up. He finally breaks down to one knee. 28's on the screen. See him there with the red flag on his right shoulder. And we know he doesn't get up again until one of the troopers or one of the EMTs cuts his vest. I know Trooper Donovan said something like he had no vitals. That's how he ended his day. This has been a huge time commitment for you all. I thank you for the sacrifice of time that you've all made for this. Mr. Abdullah also thanks you for this incredible time commitment that you've given for him. The burden of proof is beyond a reasonable doubt. You are entitled to the benefits of people, all of us are entitled to the benefit of that doubt. And there's just not enough evidence to convict him on the improper storage charges. There is not enough evidence to convict him on false name and all of the weapons charges, so much that allegedly. Great.
Gentlemen of the jury, I think what we're going to do in a moment is take as brief a recess as we can all achieve, giving everybody a chance to attend to those matters. But I'm going to ask everybody to move as really as quickly as possible so that we can hear Mr. Williams' closing argument before the lunch recess. Before I do that, I do have an instruction to give you. To the extent that Mr. Thompson made an argument about what the district attorney's office thought of its case, how the district attorney's office evaluated its case. You can disregard that argument because what any party think, first of all, there's no evidence before you of what any party thinks of its case. And the reason for that is because what a party thinks of its case is legally irrelevant. But what's relevant is what you, the jury, find as facts of the case. So I wouldn't call that an opinion. You have a job to do, which is to find the facts. But you are not to speculate in any way or discuss what you believe any party may think about its case. It's simply not relevant to what you have to decide. So with that, we'll take a morning recess. Just please do keep it as short as you possibly can.
All rise, jury exit. To start the front row, followed by backup, please bring all the items.
And counsel, please do. I'm sorry.
You know, to the extent that I overstepped as a professional trial attorney on the arguing speculation, I apologize to the court.
I don't think any apology is necessary. It's in the heat of a trial, things are said that may cross the line of this argument, but I don't think they require an apology. But I appreciate your making one anyway. But so thank you for that. In any event, if we can just keep the recess as short as it can be. All rise, jury. You may be seated. We're back in 7. Jurors, thank you. I think that was the fastest recess we've had throughout the trial, and I appreciate it for scheduling the day. We'll next hear from closing argument on behalf of Mr. L. by Ms. Racer.
Five minutes. 5 minutes out of 6 days of evidence. 5 minutes out of this whole 9-hour police encounter. 5 minutes out of a trip that the prosecution says was being planned for at least a month. The prosecutor's entire case against Mr. Lucia L. boiled down to less than 5 minutes of video footage. Footage that was taken as Mr. Lucia L. was stuck on the side of the highway with a group of men, some of whom did have weapons on them, and completely surrounded by a huge police force who was also armed. This lack of evidence, this lack of information about Mr. Lucia L., that is reasonable doubt. On July 3rd, 2021, Mr. Lucia L. did not possess any of the 9 firearms we heard about during this trial. He was not in control of them. He did not have the ability or the intention to control them. And he did not intentionally help anybody else illegally possess firearms in Massachusetts. Mr. Lucia L. is an individual. He's 5'4". He has brown eyes. He first got his driver's license when he was 18, and he's always lived at the same address in the Bronx. The prosecutor wants you to think of Mr. Lucia L. as this part of the group. He wants to mush and blend all of these 11 men together. And he wants you to hold Mr. Lucia L. responsible for other people's actions on July 3rd. But your job is to consider the prosecutor's evidence against Mr. Lucia L., not just the group. And if you do that, I know you will find him not guilty of these charges. I first want to talk with you about this group of men and what they were doing, and maybe more importantly, what they were not doing on July 3rd. This group, led by Mr. Abdullah, was driving from Rhode Island to Maine. They were going to 23 Old East Bend Road in Maine, about an hour north of Bangor, as you heard. And as Mr. Abdullah told Trooper Casey, he had several acres of private land there. Now you know from the Telegram chat that Mr. Abdullah and several of these men had been planning this trip since June. It's clear from that chat the trip was going to be a 5-day camping trip, and that the people involved in that chat were planning to do what they called training. This training seemed to be some type of military training, led by Mr. Abdullah, who's a former Marine. Now there are 2 things that I'm going to ask you to focus on when you think about the Telegram chat during your deliberation. First, and most important, Mr. Lucia L. was not a part of that chat. As you've seen from the chat itself, as you heard from Trooper Delaney, there were 48 participants in that chat. Trooper Delaney told you about messages in that chat from 5 of the men involved in this case. Jamal Abdullah, Jamil Rasool, Donald Pierre, Quinn, and Omar L. Those messages began on June 6th and ended at 10:07 p.m. on July 2nd, with Omar L. asking, where is an ideal place to park? Mr. Lucha L. is not one of the 48 participants in this text group. He did not participate in any of those chats. There's no evidence whatsoever that Mr. Lucha L. was involved in any planning for this trip. There's no evidence about what details, if any, he knew about the trip. Did he have a packing list? We don't know. Did he know the others in the group were talking about military training and the need for militia? We don't know. We don't even know what his relationship was with any of these other people who were on the highway on July 3rd. In fact, in the Telegram chat, Mr. Abdullah asked the other participants to let him know who's coming to the training. On July 2nd at 12:18, he posted, any more Moors coming? And Colonel Pierre replied, I got one other coming with me. And then 3 hours later, Colonel Pierre adds another number to the chat. That's Omar L. No one in this chat ever mentioned Mr. Lucha L's name as a person coming on this trip. All that the prosecutor has presented during this trial is that Mr. Lucha L was with this group when they started driving to Maine. That he remained with the group until his arrest around 10 a.m. on July 3rd. The second thing I want you to focus on about this Telegram chat is that the plan Mr. Abdullah made on the chat had nothing to do with Massachusetts. Mr. Abdullah's plan was to go camping in Maine with a group of men and do some type of military training. This plan becomes even more clear when you look at what was in the van and the pickup truck when the police searched those cars on July 3rd and then again in August. Yeah, there were firearms and ammunition, but there was a lot more than that too. Those cars were packed with gear. Trooper Delaney described the cars as being chock full of stuff. And it took him and other officers several hours to get everything out of those cars and lined up in the warehouse during their search. So sleeping bags, tents, clothing, food, firewood, water, bug spray. There were 2 airsoft rifles and an airsoft pistol, which are for recreational use because they shoot out plastic airsoft BB. There's a container of plastic airsoft BB. Trooper Gregory Jones told you that airsoft rifles were created for people playing war games because they don't hurt. There were paper targets. There was discussion in the Telegram chat about ordering blank, which you heard from Trooper Jones is a cartridge without a projectile, so it can't hurt anyone. It's important to remember that Trooper Jones didn't mention the airsoft rifle until I asked him about it on cross-examination. He testified for hours on direct examination about the 9 firearms he found in the cars and all of the ammunition. But he was never asked about the airsoft weapon, and he never mentioned it until I asked him that question. And it was actually the same thing with all of the candidates. The police weren't asked about that, and they didn't talk about it until cross-examination. Why? Because the police only want you to see and hear and think about firearms, as though that's the only thing that was in these cars, as though that's the only thing these men had done. Yeah, some of the people in the group had real firearms and ammunition and were planning to do some type of training in the woods with them. But not everyone had real firearms. Not everyone planned to use real firearms. And not everyone knew what the plan was. Mr. Lucha L was along for the ride, getting out of the city for a few days in the woods. The last point I want to make on the topic of what these men were doing on July 3rd is this. From the moment Trooper Casey got out of his cruiser, Mr. Abdullah was respectful, communicative, and upfront with him. He immediately introduced himself. He asked Trooper Casey to call the supervisor within the first minute of Trooper Casey being on scene. You've seen from the body camera footage and from the witness testimony that Mr. Abdullah Bey was in communication with the police off and on for the entire 9-hour ordeal. Trooper Sullivan told me that Mr. Abdullah Bey was telling the police about his movements when he opened car doors, when he took his item out of any car. He was alerting the police to everything he was doing in real time. He was also live streaming them onto various social media platforms. Yeah, all of these men were on high alert for these 9 hours, given the massive broken response that happened. The evidence showed they were scared, and they wanted to make sure that everybody made it out of that situation safely. What the evidence does not show is that there was a plan for anything to happen in that situation, or for anybody to get hurt. So as you enter into your deliberations about Mr. Lucia L., I ask you to not get distracted by any suggestion that something else was planned. There's no evidence of that. And you know, having sat through this trial, that nothing violent did happen. Now I want to focus on Mr. Lucia L. and why the prosecutor's evidence leaves much more than a reasonable doubt about his guilt. As I said earlier, Mr. Lucia L. did not participate in any planning or discussions about this year. Now, of course, you can and should use your common sense. Mr. Lucia L. went on the trip. At some point, he knew when to show up. He put on fatigues and a round vest, and he got in the car. But there's no evidence about when he learned about this trip or what he knew about it. And importantly, there's no evidence about his connection to any of these other people who were on the highway. We don't know how he knew them. We don't know how long he knew them. All the prosecutor has presented is that he was there. That is reasonable doubt. Let's talk about what the prosecutor's witnesses had to say about Mr. Lucia L. Not a whole lot. The name Lucia L. or Stephen Perez wasn't even mentioned by it until the third day of trial. That was when Sergeant Charles Lewis testified. He identified Mr. Lucia L. as the person he transported back to the police barracks after his arrest on the highway. Sergeant Lewis had never seen him before and hadn't actually seen any of them throughout the police. You also heard from Sergeant Matthew McDermott, who also identified Mr. Lucia L. as somebody that he interacted with during the booking process. But again, McDermott had never seen Mr. Lucia L. before he was brought into the police station. He didn't make any observations of him during the police encounter. These are the only two witnesses who identified Mr. Lucia L. throughout this entire trial. And neither of them ever saw Mr. Lucia L. until he was arrested. You know that Mr. Lucia L. was not one of the 7 people Trooper Casey interacted with during his first hour on scene. Because Trooper Casey identified all of those people. And you have photos. Trooper Casey told you that the first person he interacted with was Mr. Abdullah. He described a stocky man in a black ski mask, a black male. He described a tall man, Mr. Aaron Johnson, also a black male. He described the guy with a buzz cut, a Hispanic male with glasses and a close cut goatee. He described a taller person he couldn't give much of a physical description of as having stood near the rear passenger side of the van holding a camera. He described Bill Musa, who was the driver, sitting in the driver's seat of the Ford Transit van. And he described Robert Rodriguez standing near the passenger side behind the van. We know there are at least 2 people that the police identified as wearing boonie hats throughout this encounter. Sergeant Lewis testified that Mr. L. was wearing a boonie hat or a wide-brimmed hat when he was arrested. And Officer Halliday testified that one of the joggers, Mr. Robert Rodriguez, was wearing a boonie hat when he was arrested. Not a single police officer made any observations of Mr. Lucia L. throughout this 9-hour encounter prior to his arrest. So all we know from the prosecutor's witnesses is that Mr. Lucia L. was there and that he was arrested. This is important for 2 reasons. First, the prosecutor's own witnesses can't tell you a single thing about what Mr. Lucia L. was doing or where he was during this encounter. Second, the fact that Lucia L. did not interact with any police officers until his arrest shows you that he was not a person in charge here. He was not in control. He was not making decisions or plans. He was not a spokesperson. That is reasonable doubt. Now let's talk about the camera footage. This is really the prosecutor's only evidence showing anything about Mr. Lucia from July 3rd. First, I want to remind you that you are the fact finders in this case, not the prosecutor, not Trooper McDermott, not Trooper Sullivan. It's for you to decide who is who on that video. It's for you to decide what's being said on that video. When Sergeant McDermott testified on Monday, he told you that he interacted with Lucia L for about 10 to 15 minutes during the video. On the other hand, Trooper Sullivan interviewed Mr. Aaron Johnson for 1 hour, Robert Rodriguez for 1.5 hours, and Yvonne El Parra for about 30 minutes. You also heard from Trooper Sullivan that the transcript of the videos was prepared by the prosecutor. So use your own judgment to decide what is being said on those videos. Invite us. Now, you may all agree with the prosecutor's suggestion about what voice belongs to Mr. Lucia L in that video and what he's saying in that video. And if you do, I'm here to say that's still reasonable doubt. Yes, Mr. Lucia L was there. Yes, people around him had firearms. And yes, he was surrounded by a massive police presence. Using their common sense in our light of opinion, we can and should infer that this video footage shows a man who is scared, who is alert and observing the surroundings, and who's trying to make sure that everyone else gets out of the situation. This is not somebody acting as a lookout to help other people commit crime. This is not somebody in charge or in control of anything. I'm going to play a few very short excerpts from the clips that you saw yesterday. But first, I also want to remind you that Trooper Sullivan explained his body-worn camera from Mr. Abdullah Bey, was footage of approximately 9 hours. You also know there was a digital camera that made recordings of this encounter. You know there was a dash camera on the transit van that the police also reviewed. And you know that Mr. Abdullah Bey made some recordings on his own cell phone. You heard about those. So this footage of Mr. Lucia L that the prosecutor presented yesterday is less than 5 minutes of Lucia L. This is the best evidence that the prosecutor has from all of this available video. I'll play a short clip now.
Oh, gonna be all good. What's going on? What you doing? Where do you know? You want me to get on passenger right now? Or you need to drive? Oh, you just get out now. Yeah, just stay on the side of the road. Like your phone? Are you ready? I can't get arrested. Okay.
So in this clip, the speaker is asking Mr. Abdullah Bey what he should do and where he should go. This is not the voice of somebody in control. We can't see who the speaker is. We can't see what, if anything, they're doing. And you can't even tell from the video clips whether the various male voices, in addition to Mr. Abdullah Bey, is all one person or whether it's different people. I'm going to play the next one.
He's basically saying, just give us a serial number so we can show them stolen. Nothing stolen, right? Nothing stolen, right? I was going to go. Did they, yes, I don't know. Nothing with this one. I don't know. They found him in civilian burial. Yeah. But they walked right into a staging area. So they just walked right into his hand, basically. That's what they said on the news. Alright. Yeah, they're all everything is clean. They're all clean, that's why we're gonna let it go home. They're not. So that's what I'm saying. What's the point of them wanting to know if the weapons are clean, if the arms are clean, if they're gonna know exactly things.
So in this clip, what you see is Mr. Abdullah Bey talking with another gentleman who I believe the Commonwealth identified as Lamar Dow or Jimmy School Bay about the firearms and whether they're clean. And I expect the prosecutor is going to stand up here when I finish and suggest that Mr. Lucia L, standing off to the side and nodding his head, is evidence that he has some special knowledge or any knowledge about these firearms and where they came from. I also expect the prosecutor is going to argue that in that second clip where you can't see the speaker anymore, that that's Mr. Lucia, and that he's talking about the firearm. But when you watch this video, what you actually see and hear is someone repeating what other people are saying, maybe nodding their head. Mr. Lucia doesn't have any knowledge or information about the firearms that other people had on July 3rd. Now, of course, the prosecutor is going to focus on and emphasize the final clip, which we saw yesterday.
Always me? Rock solid, all right. Yeah, 1 second. Huh? No, I think it's second. Yeah, no. They've already been doing. They've been doing that.
So I'm going to ask you to keep in mind as you watch this video and think about it in the deliberation room, with all of the other evidence you've heard in this case about Mr. Abdullah. He may have physically handed Mr. Lucia that firearm for a moment while he was using both of his hands to eat food. But Mr. Lucia was not in control of that firearm. He was simply holding what Mr. Abdullah placed there and took back 2 minutes later. All of these clips, the prosecutor's best evidence against Mr. Lucia still does not show him in control of those firearms. It doesn't show him with the ability and intention to control firearms, and it doesn't show him knowingly and intentionally helping anybody else with that firearm. These clips show Mr. Lucia there, repeating what other people have said, asking questions, nodding his head, other people are speaking. But they don't show Mr. Lucia as an active participant in crime. That is reasonable doubt. It's important to remember everything that's happening around this area when you watch those video clips from Jamal Abdullah's body. Every witness who testified told you about the massive police response on the highway on July 3rd. When you look at the photos, there's some space around the group of 11 men. And I expect the prosecutor is going to argue that that means it wasn't a scary situation. But what you saw and heard is that armored police trucks were surrounding them. Well over 100 police officers responded to the area. I think the evidence shows it was closer to 200. All of them armed. Trooper Donovan told you there were 50 to 75 SWAT and SOP team officers present, wearing camouflage, Kevlar helmets, and holding assault style rifles. You can actually see some of the SOP team members in the bottom of Exhibit 29 photo. There were remote control drones, there were robots on scene with the bomb squad, and numerous police dogs. You heard all of this was being reported in real time on the news, and that Mr. Abdullah was talking to the police the whole time. The evidence shows that Mr. Lucia knew exactly what the police response was. And that would be a terrifying situation for anyone. He wasn't in contact with the police. You heard he didn't even have a phone on him. And the police were only speaking with Mr. Abdullah. So really, what were his options? Besides stay on the highway and wait out the situation, trying to stay safe. Let's talk next about what Mr. Lucia had on him that day. Besides that one clip where Mr. Abdullah hands him what looks like a firearm to hold for about 2 minutes and then takes it back, there's no other evidence that Mr. Lucia ever had a firearm. Unlike Mr. Abdullah, the stocky man from Trooper Casey's photos and body-worn camera, and Mr. Aaron Johnson, Mr. Lucia was never walking around holding or carrying a firearm. Unlike Mr. Hernandez, Mr. Lucia did not have a firearm on him when he was arrested. In some of the video clips, you can see something that looks like a loose strap across his chest, hanging there. Unlike the strap Mr. Abdullah has, which is tight across his neck and chest because it's holding the weight of a firearm, the strap you see on Mr. L is loose and we have no idea what it is or what it's for. You know what else Mr. L didn't have on him that day? Any Moorish identification cards, Moorish travel cards, Moorish tax ID cards. He had nothing on him that ties him further to this group or that shows any involvement in planning of this trip or any ties to the firearm. That is reasonable doubt. I want to talk for a minute about joint venture, which you've been instructed about by the judge, and I'm sure you're going to hear more about during the process of the closing. What's important to remember about joint venture is that the prosecutor still has to prove their case against Mr. L beyond a reasonable doubt. Under a joint venture theory, they have to prove beyond a reasonable doubt that Mr. L knowingly participated in a crime and that he intended that the crime be committed. We've also heard about several other charges against Mr. L that talk about a knowledge requirement. For example, for count one of the things the prosecutor has to prove beyond a reasonable doubt is that Mr. L knew the firearm was large capacity, or that it would accept more than 10 rounds. And for count 7, one of the things the prosecutor has to prove beyond a reasonable doubt is that Mr. L knew the firearm was loaded. If you think about all of these instructions during your deliberation, you should keep in mind the lack of any evidence that Mr. L was involved in planning, the lack of any evidence about how he connected to any of these other men, and the lack of any evidence about where most of these firearms even were throughout this whole encounter. What the witnesses told you about where they found the firearms was where they found them when they searched the cars after everybody had been arrested, after several of the men had been ordered to the firearms stacked inside the cars. There's no information about where many of these firearms were throughout the whole encounter. As you think about knowledge and intention during your deliberation, it's also important to remember there's no evidence here that Mr. L or anyone else, except for Mr. Rodriguez and Mr. Hernandez, took any steps to conceal their actions that day or to flee. You already heard several times about fingerprints. There were some efforts by Trooper Heather Sullivan, who testified in front of you, to retrieve fingerprints from firearms and ammunition. He wasn't able to get any fingerprints, and she explained that typical, that because of the material on firearms, firearm-related evidence, it's hard to get fingerprints. You heard from Gregory Jones, there were no scratch-off serial numbers on any of the firearms here. There were no efforts at all that there was no evidence at all that Mr. L made any effort to hide or conceal any of his actions or to flee. And that's evidence you can and should consider when you're thinking about his knowledge and his intentions. By now you've heard about reasonable doubt and the presumption of innocence multiple times. The prosecutor must prove this case against Mr. L for each separate charge beyond a reasonable doubt to a moral certainty in abiding conviction. It's not enough that you believe Mr. L probably possessed those firearms or probably knowingly and intentionally helped somebody else illegally possess those firearms in Massachusetts. On July 3rd, 2021, Mr. L was along for the ride. There is more than a reasonable doubt. Mr. L and I ask that you take your time, that you consider all of the evidence against him as an individual, not just a faceless group. And if you do that, I trust that you will return verdicts of not guilty.
I speak to one of the court officers.
At this point, we're gonna take the lunch recess, so as not to interrupt the Commonwealth's closing arguments, but that some before lunch is meant to try not to do. So it's 12:20. We'll resume with the Commonwealth's closing at 1:20. I think your lunch isn't here yet. But also, it should be here any minute. So hopefully, even if we just have an hour of plenty of time to eat. If you don't, just let Officer Gino know if you need any time to finish lunch. Let him know. Wait for people to finish. We just want everybody to have a chance to eat, not in a rushed manner. But if assuming you have time, we need one.
All right, you ready? Includes our third row, forward, second row.
If there's anything anybody needs to discuss, will be a recess. Thank you.
All right, stir enter.
You may be seated. It's closed back in session. ADA, the next is the prepare to its closing. Yes, Your Honor. Thank you. Everybody have to watch. I want to start with the basics. Early in this case, we had to watch Trooper Casey body cam. And there were a number of segments he watched. Statements in there made clear from the outset, apart from all other evidence, that what is happening on the roadside, that Trooper Casey essentially stumbled into when he stopped at 1 in the morning in Wakefield to check on that van he thought was a disabled motor vehicle. When he was met by Lieutenant Jamal Latimer in full battle dress uniform, body armor vest, multiple large capacity magazines attached to the vest, a large capacity rifle, the Ruger, we're going to talk about the Ruger, with a magazine loaded into it, the magazine loaded with ammunition. The statements of Mr. Latimer from the outset, which are admissible against him as well as his co-defendant, because they're part of a joint venture, made clear that what was happening was not Mr. Latimer acting alone, not a mistake. It was the very purpose of what they were doing was to make sure that they retained possession of their guns, regardless of whether it was legal or not. It wasn't. Regardless of whether the police asked them to put them down temporarily so they could figure out the situation, and regardless of whether or not the police ultimately said, you know, that they were going to make an arrest. For example, early on, Trooper Casey says, in the meantime, until then, I'm going to have to ask you guys, at that point there's multiple armed people out and about with Mr. Latimer on the roadside, put the guns down. And Mr. Latimer's response is, oh no, we are not going to do that. He doesn't say, I'm not going to do that. He doesn't say, I'm not going to do it, but let me check with them because maybe they will. I'm not going to do that. And that is consistent with what you hear him saying throughout the encounter about these being his men. He later tells Trooper Casey, we can't put our guns in. We. Later on, he tells Trooper Casey, you need to write me a ticket.
I'll gladly show up for whatever jurisdiction. We'll talk about whether that was part of a series of deceptive statements that Mr. Latimer made for a while. Trooper Casey finally says, when he's being shown various documents by Mr. Latimer, he was trying to say that they're a militia from Rhode Island, and therefore can do all these things without regard to what the law says. Okay, so according to what you're saying, if you weren't in the militia, Mr. Latimer's response is this would be entirely illegal. So that's the baseline where we start. When Trooper Casey first responds, he finds Mr. Latimer's, I would submit to you, heavily armed, the way you saw in the videos. Trooper Casey's got his flashlight, got a pistol on him that, by the way, if you watch the videos and listen to testimony, he never once threw. He just kept his flashlight and just kept talking. There's a clip you heard from Mr. Latimer's body camera, which I think really summarized it best. Even after other officers begin to respond to back Trooper Casey up because they're trying to figure out what's going on. The statement is Mr. Latimer talking to another male voice. 4 of them, 9 of us, and the other voice reminds him 11. So Trooper Casey, when he arrives on scene, finds himself outmanned many times over, and definitely outgunned. Now, you've heard a lot about what the standoff that ensued in the hours after that. So what is the significance of that? The standoff is the physical, lengthy manifestation of Mr. Latimer's determination that his men, this is the person, are not going to part with their guns under any circumstances at all. And the people that he is traveling with, see from the video of their conversations, are of one mind operation. Mr. Latimer is the mouthpiece. He's the one talking to the police. They are his men. They are following his lead. They're doing what he wants them to do. They're doing so voluntarily. Early in the encounter, you see that Mr. Latimer is very talkative. He's talking to Trooper Casey. He's talking to Sergeant Devin. He is trying to talk his men's way, out of this situation that they've put themselves in, where they are openly carrying high-capacity weapons on the side of the road, in full view of the motorists going by at one of them. So some of the deceptions starts with he gives a phony name. When Trooper Casey tries to identify him, he doesn't give a social security number, he claims not to have it. When you go from the RMV records to the DMV at Rhode Island, the name he gave is not his name. He doesn't have a social on there. It's in the records and you can look at it. That's right off the bat. Then he says, we're a militia, we're all from Rhode Island, we're traveling to Maine for training. Okay, well, they're not a militia. You've heard from a representative from the Adjutant General's office in Rhode Island, which controls all military forces associated with the state of Rhode Island. They're not in any way affiliated with that. And they're not one of these so-called historic militias, which are essentially reenactments, people that do educational, historical, and commemorative events. Groups that have no connection to what regular people would think of as military groups. That's not true. And they're not all from Rhode Island. What you learn, I know you sat there a few days about identifying people. We'll talk about that in a minute. These people are from all over, and they have been assembled by Jamal Latimer to create a militia that he wants to create and lead. There are a number of them from the Bronx, including Stephen Perez that have been before you. There's at least one gentleman from Michigan. There's Quinn Cumberlander, who you can see in the record, is also from Rhode Island. But they're from all over. But they've been assembled by Mr. Latimer for this purpose through the telegram chat. We'll talk about that. The vehicles, there's photos and evidence showing the license plates on them. Well, the plates are useless. Tells Trooper Casey mentioned the plates have long since expired, so they're unregistered. He tells Trooper Casey that he told none of his men to bring any identification, quote, because of the nature of what they're trying to do. And later on, almost at the very end, you hear him on the phone with a female voice talking about how he's later discovered that some of his Moors have identification cards on them which are compromised. So what becomes the standoff is how they are determined to retain possession of firearms of all types, despite not having licenses. It's been suggested to you that they were all extremely scared of the police response. Were they scared when you heard the recording of Mr. Latimer telling them all, they ask me any questions, your only response is going to be ask them all. They go through the back and forth call and response cheer. And then at the end he says, after saying ask Jamal, who's Jamal? And everybody laughs. Were they afraid then? Were they afraid when Colonel Pierre is standing there holding the flag and he tells Mr. Latimer, I'm feeling pretty good, I feel pretty safe, I'm glad I'm with you guys. Do you hear any of them telling them, any of the videos, they're really scared of what's happening? No. And what in fact does happen, what becomes the standoff is after it becomes obvious that nobody's going to put their guns down. The state police, they back off, they create distance. We have photographs and evidence looking north on Interstate 95. You can see there's a slight grade or hill. You can see off in the distance, there's some vehicles blocking that considerable distance from their vehicles. Southbound, there's also vehicles. And then there's a vehicle on the other side of the road, which is shut down. Because I would submit to you what the police find themselves in the position of is, we have an unknown number of people who are heavily armed with no identification, who are driving vehicles that are not registered. They are not licensed. They don't appear to have any legal authority to be carrying these military-style weapons. And despite the ways we tried to convince them to, they will not put them. And so what the posture that the police adopt is essentially a prudent, patient, backing off, creating space, securing a perimeter so that these armed individuals cannot escape into, for example, the wood line, the residential communities nearby, or get away with their guns, which they're not allowed to carry. They pull back and they let the negotiators do their work. But they don't do this for 10 minutes. They don't do it for an hour. They do it for almost 9 hours through the night, having shut down the highway through the 4th of July weekend to let this work, to let the negotiators try to, break the logjam and convince them to eventually surrender. There is no evidence of the record, but during this, that Mr. Latimer or his co-defendant, Mr. Perez, wanted anything other than to simply go on their way with their unlawful weapons. And I say they because there is evidence that they possess them as a group, and there is evidence that each is assisting the other in prolonging their possession, which is unlawful. That's the whole point of the standoff. So, in fact, there's a point in one of the clips that you heard where Mr. Latimer walks back to the Honda and he gets in and he says, we're not putting our arms down. And then you hear that sound that you heard when Sergeant Jones pulled the charging handle on that Ruger and racked around. That punctuates, makes clear his intentions for that day, to make sure that his men remain in possession of the weapons, and that each will assist the other to make that happen. Right? There's, and that's the same rifle, by the way, that you heard from Sergeant Jones, was later recovered, not only loaded, but with a round chain. I forget which counsel referred to it, but it was referred to as a so-called joint venture. It's a theory. Well, it's not the theory, it's the law that's going to be in charge for. And the evidence is that each person in the joint venture was playing a role in this. And It is not the case in a joint venture that everybody has to have a defined role or that there has to be a pre-existing plan. Joint venture by nature, people are going to play different roles. One way to think about it is General Motors. The person that works in the shop building the cars, the person that sweeps the floor, the person that's in the accounting office, salesman, and the CEO all have the ultimate objective of selling cars. But there's a division of labor. You may have noticed, for example, that during the trial of this case, there are things that I did, there are things that Mr. Rawl did. But we're working towards the same objective of presenting the case to you. The way Mr. Latimer sets up the militia, when he first does his Telegram chat, asking people to tackle all these things, training them, actually bakes into it at the outset, division of labor. And I'm going to call them, I mean, they represent themselves being militia, so that's how we're going to refer to them here. But as you know from hearing Colonel Ahern, it's an unlawful group in the sense that they're not affiliated with Rhode Island and they're in possession of these weapons. So this is from the Telegram chat. This is the first posting by Jamal Abdul-Bey. This is recovered on one of the phones he was using. You can see that at the outset, his packing list for the people that he's putting this out to, you can see in the Telegram chat that there's many people on. Bring a firearm, bring ammunition, bring 4 30-round magazines. Bring a plate carrier, which you know from Trooper Donovan from his experience with the Mass State Police Stop Team, also his Marine Corps experience as well. This is the plate carrier. This is actually the one that was recovered from Mr. Ladder. Got removable plates on it. It'll stop a rifle there. This one is the one that was recovered from Mr. Perez. If you inspect it on the inside, you'll see that it's the same manufacturer. And it weighs about the same. And in many ways, it also has similar appearance. Submit to you also designed to stop a rifle. So Mr. Latimer is posting throughout this chat about what the military units, and then he complains, it's a bit, 51 members and only 5 voted on the poll who comes to training events. No one should ask, why are we oppressed? Why aren't things changing? No one should ask, where's the militia? Then it's reported to him by Jamil Rasul Bey that somebody had been abducted on quote weapon unquote charges. Mr. Latimer is asking about that person, the date, the bail. The statements I submit here is someone hasn't been abducted, they've been arrested. And they're trying to figure out what court or which jurisdiction is going to deal with that case. It would make crystal clear if we had a community and a militia that could, would, and should have prevented his arrest in the first place. That's the motivation for generating and assembling this group of individuals from multiple states and going on this trip, this training. The Jamil Bey writes back, no matter how we put it, others still look at the militia as vital. And then we have another response from Jamal Abdul-Bey, which I submit to you, Mr. Latimer, posting this. All of these problems, we, the militia, is the solution. And then he complains they are trying to pick the militia apart, only our unity and us in the same territory to prevent it. Submit to you, this is evidence from the outset, Mr. Latimer is aware that the group he is putting together are going to be in possession of these weapons at some point in time. We had a video, we actually had several videos recovered off of one of the phones in the case. You can see Mr. Latimer on the left foreground. You can see an individual in the rear. I submit to you, he's putting on a plate carrier.
He's got the same facial features, hair, as Stephen Perez, the defendant before him. This is almost 2 hours before they're discovered in Wakefield. Mr. Perez is a Bronx resident, traveled to Rhode Island in some fashion, not a short journey, ends up in Rhode Island, meets with Mr. Latimer. You can also see Umar Dow just behind Mr. Latimer. Umar Dow is Jamil Bay, which we saw posting a few minutes ago. In this video, as they're all in that video putting on their plate carriers, putting on what Trooper Sullivan referred to as battle dress uniforms, with camouflage military style fatigues and other clothing. In fact, it is Mr. Perez and Mr. Dow Mr. Latimer turns to when he has questions about how to, what to do next. There's a conversation you heard earlier where he talks to them about whether the arms are clean, meaning not stolen. There's a point in that video, and we'll go through it a little bit later. As soon as he says that, you can see in the right-hand corner, Stephen Perez starts shaking his head. And then when the camera shifts ever so slightly, so his face is no longer in it, you can hear the voice talking about how everything's clean. So, what I'd like to do is talk about what weapons we know were held by different people. In a joint venture, it is not the case that we have to prove that each weapon was held by each person at a particular time, at a particular location. What Judge Beacon has instructed you is that if you participate in a joint venture with the intent to further the underlying crimes, you can be found guilty of that crime. So let's start with the Ruger, which Mr. Thompson displayed for you earlier. See, Mr. Latimer is holding it in his left hand. He's got that same plate carrier with the patch on it that we have here that says, if you can read this, you are within range. You can see Mr. Talk about the IDs later, but this is Aaron Johnson, I submit, and Mono Brock. There appears to be a figure here as well. But let's talk about the Ruger itself. And I've juxtaposed sticks from some of the exhibits you can compare. So you've got, we can tell it's the Ruger, first of all, from the distinctive sight on top of it. You can also look at the shape of the collapsible stock here and here. You can also look at the shape of the magazine, but also the laser sight on top and the fold down grip, which you see both in the lab photo and the body camera snip we have on the screen. So that's in his left hand. Mr. Latimer, if nothing else, is in actual physical possession of that weapon without a license. Again, here's another picture of it in the lab, just making clear those distinctive visual characteristics. Here's where officers first observed it. I believe this is the vehicle still on the roadside. You can see the grass up here. Here it is here. You can see right there, you can see the magazine I submit is attached to it. This is in the passenger side of the van. And when the glove box was opened, many of those large passenger magazines were found within. There's the arrow denotes the, what I submit to you is the magazine protruding from the roof. Again, that's a magazine that Trooper Jones, Sergeant Jones examined. It holds more than 10 rounds. You heard from Sergeant Jones. It's a semi-automatic rifle. So his ballistic certificate report is in evidence, and it can kind of be a guide for you to go through and look at each item if you like. It doesn't describe whether something is a large capacity weapon or not, because ultimately you'll make that decision. But it does tell you all the component properties you need to find for you to find it's a large capacity weapon. It's a semi-automatic rifle. Tested it with a magazine. He determined it's a rifle. The magazine that it came with was a 30-round magazine. He tested it with a 30-round magazine. Go back, you can see he tested it with item 5-1. Item 5-1 are 30-round magazines. So you can tell from just looking at those little sections of the report It's a rifle, it's semi-automatic, it discharges a shot, it holds a detachable magazine of more than 10 rounds. And again, that's exhibit 100. You can look at. Mr. Latimer walks around with that Ruger slung in front of him throughout the video. You watch them at different points. He's got his arms resting on it. At some points, he slings it over to one side. At one point, he's holding it up in his left hand. And then at one point, when he decides he wants to have some beans, he hands it to Stephen Perez, his co-defendant, by the side of the Honda. This television is kind of dark, but if you look at this video, you can see the stock being handed off and Mr. Perez reaching out to grab it. You can also see Mr. Perez's plate carrier up close. You can see that, for example, it's got what looks like radios to keep in touch with other members of the joint venture. You can also see in a little more detailed camouflage, which is consistent in the uniform of other members of the joint venture. And then, while Mr. Latimer is on the phone with the negotiator for a period of time, during which time Perez is standing with him, holding the Ruger off. You can't see it on the camera, but he's taking it. He's holding it below the lip of the Honda. He's looking around and he's telling Mr. Latimer, I see binoculars over there. They're looking at you there. And he's quite literally acting as a lookout, watching the police that are watching Mr. Latimer. And you know from the jury instructions that being present at the scene to act, for example, as a lookout or to do something else with the intent to assist is one of the ways to make a person a joint venture. After a few minutes, Mr. Latimer takes his rifle back. At no point, by the way, is there a conversation about Mr. Perez being terrified. He's upset. He's not happy the police is there. But he is still following the direction of their leader, Jamal Latimer. There's the butt stock and the rifle being handed back to Mr. Latimer. This is from his body camera, so it's looking out over the top of the butt stock. Some of the other weapons. So this individual is one of the first people to get out of the van in case he arrives. You can see he's got a movie-style hat on top of his head. Submit to you, this person was identified through the trial as Aaron Johnson. Photograph of Mr. Johnson. Here's another photograph. The one on the left is from the Telegram chat we talked about a minute ago. You can see the same boonie hat. You can see a particular feature on the vest. You see the red flag marking in the vest. You can also see there's some white markings on the left. You'll see that throughout. So the one on the left is before the incident in Wakefield. The one on the right is from Mr. Latimer's body camera during the incident. Now this is just a look at the features of the weapon. The weapon has a very, I would submit, distinctive box-shaped drum magazine. As does the post sent to the Telegram chat by Sharif Bey, Aaron Johnson. Also, you can look at the shape of the stock. There it is. You can also see in the left picture of the Telegram the distinctive forward handle. Here we have, by the way, the drum magazine, exhibit 95. You'll see throughout the video, multiple individuals are always around Jamal Latimer. At no point does anybody question anything he says or disagree with him. So this is the DPMS rifle, the one that we just looked at in photograph of Aaron Johnson. You can see, again, the distinctive sight. You can see the forward grip, which is facing down. You can also see that the shape of the hand. So that weapon is in physical possession of one of the people who gets out and is basically covering Mr. Latimer while he's talking to the police. And you can see that while Latimer is facing this direction, talking to the police, Johnson's always looking this way, and he keeps turning this way. This way. He's always got that rifle with that box magazine plugged in. The box magazine holds 65 rounds. And when it was found, it was fully loaded. This rifle, too, is a large capacity weapon. Again, Sergeant Jones's report, we know it's a semi-automatic rifle. We know it was tested with item 5-1, 30 round magazines. It was determined to be a rifle. It discharged a shot, and the barrel is the correct length for it to be considered a rifle. So that also is a large capacity weapon. The gentleman gets out while Mr. Latimer is talking to the police. It's the man in the ski mask. Photo on the left, it's exhibit 13. You can see this is from Trooper Casey's body camera. And here we see Trooper Casey's hand holding his left hand, holding his flashlight. Standing in front of him was with you was Quinn Cumberlander and Aaron Johnson after he's changed headgear a little bit later. On the right side, this is from Mr. Latimer's body camera. You can see again, I said this is Quinn Cumberlander, and you can see photo bombing him over his right shoulder, Aaron Johnson. See on Quinn Cumberlander's chest the outline of the pistol, Velcro. You can also see multiple 30 round magazines. You can also see his weapon slung in front of him in both photos. Take note of the shaping and also the relative shortness of the barrel. So there's the weapon outline. I outlined also the white writing on the vest. We'll come back to that in a moment. The plate carrier, I would submit that Mr. Cumberlander is wearing. Here's Mr. Cumberlander from the telegram chat. Again, take note of the vest. Take note of the what appears to be the same weapon in his left hand, I would submit, as well as the vest that has the same writing. You can see during the Trooper Casey body camera and the Sir Latimer body camera. One of the things, some of the evidence you've heard, a lot of what we did is we identified who people were. The reason we did that is, first of all, to present to you evidence that none of these people were actually in any form of real militia. Second of all, to show that no matter what name or date of birth they gave when it was checked, none of these people have any kind of license to carry these military-style weapons on the side of the 120. So here's Mr. Cumberland's booking photo. Here's his Rhode Island DMV photo. Again, he's another Rhode Island resident. And that's what I would submit to you is the weapon that you see him holding in photographs. Again, you can look at the shape of the stock and the sight. Note the relative shortness of the barrel. You may recall that's the one that Sergeant Jones categorized as a firearm, not a rifle, because the barrel was just a little bit too short. But in the definition of large capacity weapon that Judge Deakin gave you, and that you'll have in the jury room, it was tested with item 5-1, which is a 30 round magazine, fired. It is a firearm. So a firearm that has those properties is a large capacity weapon. And pictures also made clear that at the time he was walking around with, there appeared to be 30 round magazines with the viewport that lets you see the brass rounds plugged into it. This is a photo from the search of the van at Danvers. You can see the very butt end of a magazine for what turns out to be this pistol, the CZ pistol, in that seat. All right, we don't have photographs of any particular person holding that pistol when it's identified. We have photographs of the Cumberlander with a pistol. We have photographs of testimony of various people with holsters. But this is an item that's recovered from one of the two vehicles that the whole group loaded up in Rhode Island together as a group and departed in to go on this, what they would call a militia training. Here's the ammunition for that. That CZ pistol was tested and determined to be a firearm. And it had a magazine with ammunition. There's another pistol in the center between the two seats of the van. That's the one that has the black fabric holster you can see center. All right, and that one is tested and determined to be a pistol. It's measured, it's test fired. There's also found ammunition and a magazine that fit it. Those are all listed in Exhibit 100. There's a pistol that didn't come from the van that you heard about. It comes from this man, Alfredo Hernandez. the driver of the van. He's the one that Trooper Casey may remember. He's at the window and you can barely hear him say, travel, we're not doing this travel thing. You need to have a license to drive in Massachusetts. And he gets a card. Well, card is an evidence. You can look at it. It's got the same photograph as this card, Exhibit 33, which is found on the person of Wilfredo Hernandez when he's apprehended by the Wakefield police out for a jog in camouflage when the whole town is shut down because of a reverse 911. That's the pistol that's, I believe, Captain Buckley described removing from the front of him when he was apprehended. He's wearing the same kind of camouflage. It's the same identification or same photograph for the identification presented to Trooper Case. Yeah, Mr. Wilfredo Hernandez is another Bronx resident. He did not teleport into Wakefield. He, like the others, I would submit, came from New York to Rhode Island with Mr. Latimer and all the others, including all the other Bronx members of this joint venture, donned their, what I would call a uniform, loaded up the van, made another drive into Massachusetts, stopped, and was with the other members of the joint venture who were doing everything they can to retain possession of their weapons without getting up to the police till 6 a.m. or so when he's apprehended along with Robert Rodriguez in Wakefield. And he's not apprehended in a way that suggests that he was trying to surrender. He's apprehended in a way that suggests he's trying to find a way to escape. They find him jogging along the road and by happenstance basically blundered into police presence there. So we have the magazine for that. The pistol itself, we have in evidence. Taurus pistol, Exhibit 99. And unlike the other ones where the search and photographs taken, this was removed from his person. We have it here, and you can look at it. The ammunition for it. This is the magazine with the ammunition. Here's Sergeant Jones's report. Again, it's test fired. It's determined to be a firearm. And because the barrel length is a certain length and it discharges a shot. And the ammunition with it is also determined to be ammunition, meaning it has all the properties of it. All right, now this is a picture of the back of the Honda, back seat. And you can see that there's a couple different objects here. We're going to talk about this one first. This is the pistol that looks like a rifle, sort of. Exhibit 119. Has the micro conversion kit around the pistol. That's one of the magazines for it. The ammunition that's in that magazine. Magazine was 2-10. When the ammunition came out of it, it was made 2-10.1. Operable pistol, which is a firearm. Magazine ammunition was also live ammunition. There's a second magazine located for it. There it is. Exhibit 119. There's the ammunition that was in that. That too was tested at 15 to 100, and it had the properties of it. In the front passenger seat of the Honda, we have the shotgun. See it here resting diagonally against the center console. There's the lab photo of it, Exhibit 123. That too was tested, determined to be fire, and it has all the properties of a shotgun. The ammunition, including the ammunition loaded in the chamber, was also tested. That's in Exhibit 100. The other items in the back seat, you have this longer item. It's the bolt action rifle. It has that long scope right there. There's the lab photo, Exhibit 124. Also tested, determined based on the length and the fact that it fired a shot, it's a rifle. Then Sergeant Jones went through other items recovered, which are going to be relevant to the different charges we're going to consider. First, we have 3 AR-15 or M4 style magazines that hold 30 rounds each. Those are in evidence. The For exhibits 87, A, B, and C. They're in the big envelope. See, these don't have a viewport. You can see that they have ammunition in them. They're loaded. They were loaded when they were found. They were unloaded to confirm their capacity and their freedom. There are 3. There's also the other drum magazine. Here it is, exhibit 86. It's the same caliber as the pistol with the micro conversion kit, 40 caliber. There's the 3 magazines found in the console of the Honda that I just showed you. There's the drum magazine on the floor, the one that I'm holding there. This is, I believe, a 50 round capacity drum magazine. There's also, in the van, we have 20 of those AR-15 M4 style magazines, each of which was loaded with 30 rounds. We have those. I think approximately 13 of them were found in the glove box next to the Ruger, which is the same caliber as these. There they are on the table, laid out, 13. Then there was a white trash bag under one of the seats, from which 7 additional magazines were recovered to make up 20 in total. There they are on the screen. Then there was the box for drum magazine that I showed you earlier. We were talking about Mr. Johnson at exhibit 95. Again, found loaded, unloaded, reloaded, test capacity, 65 rounds. We actually already played this video, so we'll come back to that. The other thing we did is we identified everybody to show you the absence of licensure, and we'll go through this quickly. Because then we'll come back and talk a little more about the joint action. So this is the juvenile on the left here, Brandon Britton. We have not only his New York State DMV, this is just the first page, but the rest of it is in evidence too. You can look at it, all the biographical information. We have a birth certificate. He was under 18, but they had a teenager. The gentleman standing to his right, his left, excuse me, Omar Antonio. We also have, these are his, this is a, we'll call the one on the left a candid photo from Jamal Latimer's body camera. The one on the right is a book photo. We have records and evidence identifying him too. We also have, we talked about him briefly before, Lamar Dow, otherwise known as Jimmy Bay. The left is his booking photo. The right is the one that he shared with the Telegram chat. You'll notice if you go back and watch the videos where he's standing next to Stephen Perez, he's got a very similar green set of head covering on. He's got a nearly identical looking body armor vest, or I submit as body armor. You can see some Velcro here in this photograph. When you look at the one that the photo is captured by Mr. Latimer, there's all these shotgun shells. The next individual standing to the next to Mr. Lamar Dow is Colonel Pierre. This is both a photograph in Massachusetts DMV or RMV information. Here are some photos of him up on the left. This is him with Lamar Dow. There was testimony about a distinctive patch on his vest. You can see it more clearly in Exhibit 68L. You can also see the same green head covering in both photos. The 68L is when you share with the Telegram chat. As the user, Colonel Pierre. And there's the distinctive patch on both vests. In this photograph, exhibit 133, you can see that he's standing next to Omar Antonio, who are in turn next to Quinn Cumberland, the only person that consistently wears a black ski mask all the way pulled up. So in the center, or that's highlighted here, 21A, you have Mr. Latimer. You can tell it's him again from the so kind of a brownish covering. We already talked about Queen Cumberlander. Savant El Kara at the very end. And we have this photograph showing Aaron Johnson, we already talked about. And I submit to you, this is Stephen Perez, based on the facial feature, stature, the best. Booney had her testimony about, I believe there's testimony about recognizing what Barrett's photographs did. And this is Mr. Rodriguez, who was one of the other members of the joint venture, who was with the Honda pickup truck. He was apprehended with Wilfredo, I would submit, the joint venture who was carrying a pistol by Wakefield police. We come back to Stephen Perez's time at the side of the road, various statements. The transcript you've had before has statements where you can see his face. He's identified as Stephen Perez. In the same transcript, as soon as he's off camera, same voice is referred to as disputed male speaker. But if you listen carefully to the voice, and you can do that, we'll do that in a second. We'll start with the last video and work backwards because that's the clearest way to do it. You can also compare it to the voice exemplar we played for you several times, where he's talking about the Moors. You know, many members of the joint venture had so-called Moorish identity cards. Mr. Perez did not. And I think it's clear from Mr. Latimer's statements that he did not want anybody to bring any form of identification. So this, I would suggest, makes him a good follow-up. But his statement, his voice exemplar, he's talking about Moorish. We'll come back to his statement in a moment. Right, so if you go back to Operation Fountainhead, when it's posted in the Telegram chat, it's also going to be a joint venture because you need different responsibilities. He's soliciting a medic, he's soliciting a range officer, he's soliciting different shared responsibilities. And really, no form of organization would be a better example of a joint venture than a military or paramilitary unit. A leader, single objective, following instructions, division of labor. Even the very idea of wearing a uniform suggests that you're trying to be part of something. That's what's going on here. So it's been suggested that there's only 5 minutes of evidence against Mr. Perez. He's just present at the scene. Well, he's present at the scene for 8.5 hours, during which time police are all around. They're shouting, and at one point on the phone, Mr. Latimer, trying to get everybody to give up peacefully with the guns. Mr. Perez is one of the people armed like he's going, or not armed, dressed like he's going to war. Is it really a credible argument to suggest that he didn't know of the plan, he wasn't aware of what was going on, he somehow blundered into this and just had no idea, despite having traveled from New York to Rhode Island, back up to Wakefield? I would suggest no. Certainly, the vehicles or the police vehicles around are plain for everybody to see. Certainly, everybody walking around with large capacity weapons in the roadway is plain for everybody to see. Certainly, when Jamal Latimer asks him and Lamar Dow, after talking to the negotiator on the phone, well, they just want us to give the serial numbers. Can't be the case that he has no idea what's going on. In fact, it seems very obvious that as he starts shaking his head, he says, no, it's all clean, and then says to the effect, we give them the serial numbers, aren't they still going to arrest us? By the way, in the video where they all got dressed in Mr. Latimer's house, I would submit, they're all putting on their plate carriers even before they're going to their, what's been described for you as a camping trip. So they're going on a 5-hour drive to northern Maine, and they're going to put on these heavy-duty, rifle-stopping, metal pieces of armor. Mr. Latimer comes back to him. Again, ultimately it's your determination whose voice it is. But I would submit to you the disputed male speaker is handed fine. Question is, for I would submit Mr. Perez. Okay, so if they try to arrest anybody, what's going on? What we doing? Jamal Latimer responds, we already know. Not I know. Not don't worry about it, doesn't involve you. They know. We know. Mr. Perez then says, all right, so you want me to get in the passenger right now or stay in the driver's? Okay, so that suggests that he's been the driver of the pickup truck. By the way, both vehicles that Mr. Latimer tells the police are his and are loaded at his house in his presence with the people that he brought to his house. You can just get out for now, says Mr. Latimer. Mr. Perez, I submit, then says, armed? It's simply not the case that he had no idea what was going on. You know, it's been criticized as only being 5 minutes of evidence. It's really 8.5 hours of evidence because he remains with his leader for the whole time. And even if it were 5 minutes, it's the quality, not the quantity that matters. Here you have the words out of his own mouth indicating he knows that they're dealing with weapons and he knows that there's an issue about surrendering to the police. And he's just not interested in doing it. There were statements made to you about Mr. Latimer after he sat on the bucket. There was testimony that he sits on the bucket, Quinn Cumberland takes his rifle, puts it in the van. Ultimately, they give up and they're arrested. And Mr. Latimer, the testimony of the argument was had no violence. That's if you go back to what Trooper Donald said, it's not actually correct. He wouldn't come to them. So the stop team, after everybody else was arrested, approached him slowly, took him into custody, had a medic check him out. They cut his vest off and checked him for medical issues. And they took him to a hospital. By the way, this is a person that had been fine with walking around with a 20-pound piece of armor on, carrying weapons on him. And yet suddenly, as he's about to be taken into custody, he develops an issue that requires hospitalization. Throughout this, and you can go back and watch the videos, the police are doing what they can to buy time, but let talking, not violence, carry the day. You can see it from Casey. You can see it in Devitt, who was at least trying to hear them out. You can hear the negotiator talking to Mr. Latimer in one of the videos. I want to just play one of the videos to emphasize the point of Mr. Perez's voice. I'm going to start with the video that's in I think it's exhibit, it's the Latimer body camera footage. It's the last, I believe it's the last video we watched. It's the file ending 25221. So he's at the window side, he's talking to somebody. You're going to see the face in a minute. Listen to the voice of the person who responds to him through the window.
Today, what happened? When they anything, are you happy? Astronaut. Right? You don't have to tell them, you don't even have to say that. You can just stay quiet. But it's better to just say astronaut.
Right. You can just barely see to the right. You can see the face. And if I play it again. I submit you can see the top half of Mr. Perez's face over Mr. Latimer's left arm. He's asking about it if they get locked up. You can also see into the vehicle, I submit that's Brandon Britton on the far side of the vehicle.
I mean, they technically have to, but they probably won't.
So that's one video where you can at least see a good portion of his face. Look at another one. Well, so listen to the things that you can see Stephen Perez saying after he takes Mr. Latimer's rifle and while Mr. Latimer's on the phone with the negotiator.
I'm gonna drop Raleigh and race. Okay, so here's the thing. It's already going to go recording. I already know it's going to record. Absolutely.
Call me. Right, but like, we need to be patient. This is the anything else to say in the show.
Can you tell your men to not arrest us right now? We're trying to eat food. Can you tell your men to not? Can you tell your men to not arrest us right now because we're trying to eat food before we get put in a cell with garbage food? Yes, absolutely. Your men are doing funny stuff. They're in the front. Yeah. I'm sorry, I'm speaking to my men at the same time.
So this guy's watching you. You can't make out all the things he's saying, but you can hear the tone of the voice. You can take that and go listen to the other parts of it. Like, for example, when Mr. Latimer comes back to the Honda in the middle of the night, and the question is, so if they try to arrest somebody, what we do? We'll play that right now, since we just heard a part where you can see his face.
Yeah, absolutely. So I didn't understand. Do that, please. Yeah.
We might have to get ready because they're talking about a possibility of an arrest.
So they're talking about the possibility of an arrest. So the captain said he's gonna read the case law I gave him to see if we violated any laws, and if not, we're gonna be on our way. Where do you know?
And then after that, there's the conversation with Mr. Latimer. Out of the earshot of the police, starts telling his men to take up sniper positions. They aim down range. In case that the police come toward them, spread out. Again, all of these things are the groups, the joint venturers' manifestation of their knowledge of these guns and their determination that they will retain them in any way that they can. All right. Finally, a couple other, I only have one or two more points. It was, you have before you, the verdicts that you have a series of items on them, and you have with testimony, you've gone through nearly all of them. You also have, if you wish to see them, the boxes of the ammunition, but you remember Sergeant Jones went through it all with you and essentially testified that it was all operable live ammunition, within his opinion as a ballistics specialist. You know, in this case, there were a lot of arguments made about, you know, essentially that it seems like the argument is that perhaps it's only Mr. Latimer who was doing things. But if you look at everybody, if you look at the coordination, everybody played a role in the joint venture. You know, seeing is believing. We have the videos, we have the statements, where you can listen to them many times as well. When you do that, and you carefully review, you look at how each person did things and reacted and responded to this 8.5-hour standoff. And you learn that, for example, you know, you examine the plate carriers in more detail, you look at the photographs, you look at the various weapons and evidence. You look at the documents suggesting that Mr. Latimer had a good motive to conceal his identity from the police because he had an open warrant. And then Mr. Thompson argued to you that ultimately nothing came of it later on. That was in the future. That's not who Mr. Latimer knew to be preordained. You actually hear at one point he says, "I'm not going to get arrested as huge terrorists." And then explains why he uses false information to conceal his identity from the police that was to the best extent. So when you consider all this carefully, you'll be able to take as much time as you need. The only verdicts that will be supported by this evidence are guilty as to all defendants as charged.
Mr. Banks. May we be heard briefly on the list for devices?
You may.
Last brief instructions I need before we take the final steps to reduce the jury to 12 and select a 4-person. Jurors, you must decide whether the Commonwealth has proved beyond a reasonable doubt that each defendant is guilty of each of the specific offenses charged. You may not find them guilty on any charge just because you think they did something else that was wrong or improper. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. When all 12 jurors agree on the verdict, the 4-person should check off that verdict and then sign and date the form to be. Jurors, as I said at the beginning of the trial, yours is the most important role in this trial, because you must decide whom and what to believe, and whether the Commonwealth has proved each defendant's guilt beyond a reasonable doubt. You must be completely fair and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly, carefully, and dispassionately. Do not be influenced by the nature of the charge, sympathy for anyone involved, or the possible consequences of your verdict. Do not let your personal feelings about any person, criminal charge, or anything else influence your decision. You must decide this case based only on the evidence presented at the trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence. And you may not base your verdict on suspicion, guesswork, or speculation. As I told you earlier, you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of witnesses, as you recall it, and the things that were marked as exhibits. You will have the exhibits with you in the jury room. Things that were marked only for identification are not exhibits, and you will not be able to consider them. I want to briefly, this is not in the text that you have, but I want to explain one protocol with respect to evidence in cases involving firearms and or ammunition. Neither the firearms nor the ammunition will be sent in with you automatically into the jury room. But you may request to see one or more than one of the alleged weapons, and they will be sent in to you as you request them. You request to see all the weapons at the same time. Similarly, you may request to see any item of ammunition or related items such as an alleged magazine. And you may ask to see one item, more than one item, or all such items. But under no circumstances will I allow both alleged weapons and alleged ammunition to be in the jury room at the same time. So it makes it a little bit, you have to work through the logistics. And please understand, anything that you want to see, send us a note, ask to see it, and it will be sent in to you. The one exception is no alleged weapon will be sent in at the same time as any alleged ammunition, and vice versa. And that's just for obvious reasons of safety. Other things besides things marked for identification, other things that are not evidence, other things are not evidence, and you may not consider them when deciding this case. That Mr. Latimer Abdullah Bey and Mr. Perez Lucha L were indicted, that is, charged with crimes, is not evidence. Questions that a lawyer asks of a witness are not evidence. Only the answers are evidence. And of course, you can use the question to understand the answer, but standing alone, the question is not evidence. For example, if a lawyer asked, "Wasn't it raining outside?" and the witness answered no, or "I don't remember," or said, "Well, it was cloudy," the question is not evidence that it was raining. When a lawyer asked a question and I sustained an objection and therefore the witness did not answer it, then neither the question nor the witnesses following my instruction in not answering is evidence. When I struck or told you to disregard any part or all of an answer by a witness, then that part of the testimony is not evidence and you may not consider it. Anything that you may have heard or seen or heard when the court was not in session is not evidence. The opening statements and the closing arguments of the lawyer are not evidence. And this is vitally important, if your memory of the testimony differs from the attorney's, you should, in fact, you must rely on your memory. Any notes that you may have taken are not evidence, but you may use your notes to refresh your memory of the evidence. As I instructed you during the trial, you will note that in some of the exhibits, some information has been obscured, redacted. In those cases, information that is not admissible in evidence has been removed from the document. You are not to speculate about what that inadmissible information is. Do not consider it in any way. We have removed inadmissible material to ensure the evidence is presented in a fair manner, and that you hear only, I guess I should say hear and see, only evidence relevant to the issues in the case. You are not to engage in any guesswork or speculation about what has been excluded from your view. You are to decide the facts only from the evidence that is before you. You likely have noticed that Mr. Latimer of Hula Bay and Mr. Perez Lucha L did not testify in this trial. As I explained to you at the outset of the trial, you may not hold that against them in any way. Like any person in Massachusetts, and indeed in the United States, charged with crimes, Mr. Latimer of Hula Bay and Mr. Perez Lucha L have an absolute right not to testify, because the entire burden is on the Commonwealth to prove their guilt beyond a reasonable doubt. It is not up to the defendants to prove that they are innocent. Under our laws, Mr. Latimer of Hula Bay and Mr. Perez Lucha L have the right to say to the Commonwealth, as they are indeed saying, you must prove your case against me beyond a reasonable doubt. I do not have to say a word. That the defendants did not testify, therefore, is not evidence because it has nothing to do with whether they are guilty or not guilty. You must not draw any inference against Mr. Latimer of Hula Bay or Mr. Perez Lucha L because they did not testify. It is not evidence, and you are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendants beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits in the case. As you know, and certainly now know, evidence can come in many forms. It can be testimony about what someone saw, heard, smelled, or felt. It can be someone's opinion, and it can be an exhibit. Some evidence proves a fact directly. We sometimes refer to this, I guess not surprisingly, as direct evidence. For example, if a witness testifies that the witness saw and felt it raining outside before the witness came into the courthouse, then that is direct evidence that it was raining. In that case, all you have to decide is whether you believe the witness. Some evidence proves a fact indirectly. We call this indirect or circumstantial evidence. For example, let's say a witness testifies that the witness saw someone come into the courthouse wearing a wet raincoat and shaking water off an umbrella. That is indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove that something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some information that we know, we apply our intelligence and common sense, and then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. If, however, the evidence would support equally two contradicting inferences, then you may not draw an inference either way, as that would require you to engage in speculation or guesswork. It makes no difference whether evidence is direct or indirect. The Commonwealth may be able to prove a criminal charge with direct evidence, indirect evidence, or a combination of both. It is also up to you to decide how important each part of the evidence is, whether it is testimony by a witness or an exhibit. Whether evidence is direct or indirect, you should give every piece of evidence whatever significance you think it deserves. You are not required to believe something simply because it appears in an exhibit. It is up to you to decide how important any exhibit is. You do not have to treat testimony by the witnesses as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is equally or even more important. That type of determination is entirely up to you. A very important part of your job as jurors is to decide whom and what to believe. You may believe everything a witness says, some of it, or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or was deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. Excuse me for 1 second. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without needing to do so. A witness may recall seeing or hearing something, but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of the person's testimony was not accurate, then you should not consider the inaccurate testimony. How do you decide whether you believe particular statements by a witness? Ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Does the witness's memory seem accurate? Was the witness's testimony consistent with other evidence or instead contradicted by other evidence? How did the witness behave and answer questions? Did the witness have any motive for testifying in a certain way or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way you would evaluate anyone's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. You may consider any statement made by another defendant or participant in the alleged joint venture as evidence against Mr. Latimer Abdullah Bey and or Mr. Perez Michael only if the Commonwealth has proved three things about the statement. First, that other evidence apart from the statement shows that there was a joint venture involving the speaker and the defendant. Second, that the statement was made during the joint venture. And third, that the statement was made to further or advance the joint venture. Only if the Commonwealth proves these three elements by a preponderance of the evidence are you allowed to consider the statement of another defendant or alleged co-venturer when you are considering the charges against each defendant in this case. Something is proved, and I want to emphasize this because this is one place where you're encountering a different standard of proof. Something is proved by a preponderance of the evidence if, after you consider all the credible evidence in the case, you are persuaded that the fact is more likely true than not true. And that's distinct from the standard of proof by which the Commonwealth must prove the elements of each of the offenses, which is beyond a reasonable doubt. So in this one instance, the Commonwealth's burden of proof as to this issue is by a preponderance of the evidence. If the Commonwealth has not established those three elements to you by a preponderance of the credible evidence, then you shall not consider the evidence against each defendant. In that situation, each of the defendants is entitled to have the case determined solely from the evidence about his own acts and statements. A statement of a fellow member of a joint venture may be used against the defendants in this case only if the Commonwealth has proved all three things by a preponderance of the credible evidence. Most of the testimony in this case came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But even if a witness has some special training or experience, that does not necessarily make the witness's testimony any more believable or important than other testimony or exhibits. You must decide whether you believe the witness and how much importance to give to the witness's testimony. If you consider all the factors I previously mentioned, including whether the witness had a motive to testify in a certain way or some other bias that could have influenced the witness's testimony, In addition, as you evaluate a witness's opinions or conclusions, you should also ask, was the witness's testimony supported by the facts of this case? Did the witness use guesswork or assumptions that you do not find to be convincing or not consistent with the facts? Did the witness have sufficient education or experience? You may decide to accept all, some, or none of the opinions or conclusions offered by a witness. But please remember that witnesses, even those with special training or experience, do not decide cases. Juries do. You, the jury, decide what the facts are, not the witnesses, no matter what their expertise. It is up to you to decide this case and decide whether you accept or reject any opinion or conclusion that a witness offered during the trial. Much of the evidence that you have heard was admitted without limitation. We discussed this a little bit during the trial, but it bears repeating. That means that you may use it for any purpose for which you find it is relevant to the issues of this case. Other evidence, and I've identified it for you when it was admitted for a limited purpose or purposes. If evidence was admitted for a limited purpose or purposes, you may consider it only for that purpose, those purposes, and not for any other purpose. I will now go over that evidence more particularly. Yesterday, Exhibit 132, an Attleboro District Court record, was introduced in evidence. As I explained to you then, the record was introduced for the sole purpose of establishing that as of March 20, 2020, a warrant had issued for a Mr. Jamal Latimer of 44 Carr Street in Providence, Rhode Island. You may use that exhibit only insofar as it helps you, if it does, evaluate the charge against Mr. Latimer of Dula Bay for providing a false name to a police officer in connection with an arrest. You may not use it for any other purpose in connection with the charges against Mr. Latimer of Dula Bay. Additionally, you may not consider Exhibit 132 in any way in evaluating the charges against Mr. Perez and Michelle. Another exhibit, number 127, a voice exemplar, also was introduced for a limited purpose. That purpose was to help you, if indeed it does, to identify the speaker, to identify the identity of the speaker identified in a transcript as disputed male speaker. You may consider it only for that purpose, if you find that it assists you. Specifically, you may not draw any inference for or against either party based on the content of the voiced exemplar. In connection with some of the reported exhibits, the Commonwealth has prepared unofficial transcripts. Their purpose in presenting them to you is to help you understand what is being said in the recordings, if they do. You may use the transcripts to help you better understand what is being said in the recordings, if indeed they do. Bear in mind, however, that's fairly repetitive. Two sentences say essentially the same thing, that is inadvertent. Bear in mind, however, that the transcripts are not evidence. It is the recordings that are the evidence. And if what you hear in the recordings differs from what is in the transcripts, then you should base your decision on what you hear in the recordings. Finally, in one of the transcripts, some of the statements have been attributed, as we discussed a moment ago, to a disputed male speaker. This designation reflects that the parties do not agree as to the identity of the speaker in those instances. It is therefore your duty to determine whether the Commonwealth has proved by a preponderance of the evidence who the speaker is. You will recall that at one point in the trial, I took judicial notice of the design of the Moroccan national flag. I told you that it was a red flag with a green 5-pointed star in the middle. As I explained at the time, judges are permitted to instruct jurors on issues of fact that are widely known and readily verifiable. What a country's flag looks like is that sort of issue. Because I have taken judicial notice of the design of the Moroccan national flag, you must take that description as true for the purposes of this trial. Many of you, maybe all of you, but at least many of you, have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony, but of course they are not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Your notes may help jog your memory about what a witness said, but they are not a substitute for what you or other jurors remember about the testimony. Do not assume that because you or another juror wrote something down, that it is more accurate than your or another juror's memory of what the witness actually said. Whether you took notes or not, you must rely on your own memory of what the witness has told you. As I mentioned at the outset, after the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. During the trial, the lawyers objected to questions posed to a witness or exhibits offered by the opposing party. They may have moved to strike or, in essence, erase certain testimony. In fact, they did. Whenever a lawyer believes that something would violate the rules of evidence, the lawyer is supposed to object and move to strike. That is part of the lawyer's job. Let's turn now to another important issue. Each of you has taken an oath to be and promised to be fair. I am sure that you want to be fair, but it's not always easy. Part of being fair is being willing to examine your decision-making process to be sure you base your decision as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them. We all have them simply because we are human. They affect our actions and decisions without us even realizing it. We judges have the same problem as everyone else, so let me share a few strategies that we have found useful. These strategies will help you to make sure you decide this case based only on a careful examination of the evidence and on the legal rules I've explained to you. First, slow down. Do not rush to make a decision. Take time to consider all the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we may not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were in different social or economic groups, or had different ages, genders, gender identities, or sexual orientations, or came from different racial or ethnic backgrounds? Fourth, listen to one another. Other jurors may have different points of view. If so, they may help you make sure you are focusing on facts. Of course, other jurors could be influenced by their own unstated assumptions, so don't hesitate to share your views. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to other jurors, you help everyone focus on the evidence. If you do these things, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. I'm now going to give you some instructions about how to conduct your deliberations. First of all, you must keep your deliberations secret. You should not tell anyone outside the jury room, not even me, anything about them. For example, please do not tell me or anyone else the results of any votes you may have taken before you all agree on the verdict. You must not tell anyone how your discussions are going or what any jurors said. If you need to communicate with me before you reach a verdict, you should send me a written note in a form you all agree on. It must be signed by your foreperson. I will discuss your note with the lawyers. Then I will either send you a response in writing or bring you into the courtroom and respond to you in person. If you do send me a note, it should not mention any votes you may have taken or anything else about your deliberations. Do not talk about the case unless all of you are present and no one else is in the room. If one of you needs to leave for a moment, the rest of you should stop deliberating until that juror returns. If we break to the day before you reach a verdict, you must not communicate with other jurors about the case until the next day, and only after we gather in the courtroom and I ask you to resume your deliberations. The next part about having lunch brought to you obviously doesn't apply to today since we've already eaten lunch. But on any day that you're deliberating at 1 o'clock, you will have lunch brought to you. If you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to those deliberations. Or you may decide as a group that you'd like to work through lunch while deliberating. Either way is fine. The only thing we can't have you do is some of you have lunch and others deliberate. That doesn't work. Whatever you do, do it all together. The foreperson, again, will ensure that you are all working together as a jury in this case. As you work to decide this case, and until I accept your verdict, you must not communicate with anyone about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with an electronic device such as a cell phone or tablet. This also applies equally to the alternate jurors.
Speaking of alternate jurors, the law permits only 12 jurors to participate in deciding a case. There are 14 of you here, so in a moment, our clerk, Ms. Noble, will randomly select 2 of you to be alternate jurors. The other 12 of you will work together to decide this case. We chose, and it says there 16, but obviously it's 14. We chose 14 of you originally in case anyone got sick or had some other unexpected emergency. And it says here, as happened in the case of 2 of your fellow jurors, you're getting a little sneak peek into a different case than when I cut and pasted I edit problems. So we chose 14 of you in case any one of you got sick. Fortunately, that didn't happen to any of you. So we still have 14 and must select 2 alternates. If you are chosen as an alternate, your continuing service is still very important. You must comply with all the rules I have given you. The alternate jurors will stay in another room and must not discuss the case with each other or with anyone else. If we lose a deliberating juror because of some personal emergency or sickness, then I will send one of the alternates to the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. As I mentioned, one of you will serve as foreperson of the jury. I will explain in a moment how the foreperson will be chosen. The foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinions about the case, their opinion about the case is no more important than the opinions of all other jurors. Once you agree on a verdict, the foreperson will fill out the verdict form and will report your verdict to the court. When you work together as a jury, you will be making a decision as a group. This kind of decision making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You have all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, and now I'm quoting, well and truly try the issues between the Commonwealth and the defendants according to the evidence and the law, on that quote. So you are all equally qualified to reach a verdict. I have a few suggestions that might help you as you work together. First, you should discuss and analyze the evidence before you take any vote about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as other jurors talk about the evidence that they found important, please listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your thinking. Fourth, don't be shy. As in any group, some of you will be more comfortable than others in sharing your thoughts. But you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one who remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective the deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept the decision just because other jurors think it is the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, you each must decide this case for yourself. Jurors, before I conclude, I need to pause again briefly and speak with the attorneys over the heads. It is now time for our clerk, Ms. Noble, to randomly select 2 of you to serve as the alternate jurors. Ms. Noble.
Jarrett in seat number 7 and Jarrett in seat number 3 will be the jurors, alternate jurors.
Okay. So the jurors, seat number 3 and seat number 7, if you could just raise your hand so I know that you know who you are. Thank you. And I will just say that every time I talk to a juror after a trial, the alternate jurors tell me that they are disappointed, or almost every time. But what you need to understand is that your role is vital, because as I said, if anything happens to a deliberating juror, you will have to be, one of you will have to be sent in to participate in the deliberations. So you provide us with essentially insurance that we will be able to, the jury will be able to reach a verdict in this case. But I saw disappointment on both your faces, so I did want to say that it's vitally important to the role that you're going to perform. Jurors, when you begin to meet in private, your first responsibility is to select one juror to serve as your foreperson. You may do so however you wish. Once you've picked your foreperson, please send me a note through the court officer that tells us which one of you is the foreperson. If for any reason you cannot quickly and easily select a foreperson, then send me a note asking me to do so instead. You swear the court officer does not.
Do you solemnly swear you will keep this jury committed to you at this time in some convenient place until they have agreed? That you will suffer no person to speak to them, nor speak to them yourself unless by order of the court or ask if they have agreed. And that you will not suffer them to disperse until they have been discharged of their verdict unless by order of the court, so help you God.
I do. The deliberating jurors will now go and start their private discussions. Please have confidence in what you are about to do. By serving on this jury, you carry on a long and proud tradition of citizens serving in jury trials in Massachusetts. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict.
All right, jury agent, who's held the first roll, followed by second roll, please bring all your items. All rise, jury agent. You can be seated for the back of the session.
Jurors and deliberating and alternates, thank you for what was clear to me was your careful attention to all the evidence in the case, and now the beginning of your work in deliberation with deliberating jurors. I need to remind you, because these instructions continue to apply to you. In fact, if anything, they're more important than ever. So please bear in mind that none of you may discuss this case or the evidence in this case with anyone. That includes alternate jurors as well as deliberating jurors. And as you know, discussions include not only face-to-face and telephone discussions, but also using cell phone or other electronic devices to text, chat, email, tweet, blog, or post anything about the case on social media, other electronic media, or anywhere else. Please continue to have no communication with the lawyers, the parties, and witnesses in this case, and I expect they will do the same with respect to you. You must not read, watch, or listen to anything covered about this case in traditional media, social media, or anywhere else. Please remember my 2 instructions. If you are exposed to any type of coverage, first, to minimize the information you take in as best you can. And second, if you are exposed to any type of coverage, please don't mention it in any way to your fellow jurors, but instead take your court officer aside when you're next to the court officer and you can tell them in private what it is that you were exposed to. Finally, please continue not to do any research or investigation about this case, online or otherwise, or allow anyone else to do so for you. So with that, and understanding you've only just begun your deliberations, we're going to recess the long trial weekend and ask you to be back for Monday morning at 9 a.m.
All right, for the exam, we'll tell the first roll, followed by second roll, and off the jurors, please.
Hey,